If everyone was Putin Nagar, we shall never die. Should continue like. What time is it? Usually to use hangi baat khulao na nae.
May I please, Your Lordship?
Yes.
Lordship, I'd like to mention item number 1 on behalf of my colleague. If this matter can be listed after 3 weeks, Lordship. Item number 1.
Under prayer of so and so. Learned Council appearing for
Vishimomi.
so and so. Praise for adjournment of the matter for 2 weeks. Let the matter be listed after 2 weeks.
Lordship. Lordship, I have submitted prayer for item 4 as well, Lordship.
Item number
4 on behalf of Vishimomi.
4 also same order.
Lordship, if this item can come up on 10th of November, Lordship.
Let the matter be fixed on 10th November.
Okay. Obliged, Madam.
Obliged, Lordship.
Please, Lordship, I beg to mention item number 2.
Item number
2.
2, yes.
Yes, I've taken the consent of the opposite party. Lordship, here the final hearing is fixed on 26th of November before the DC Chumakidima. So, Lordship, I pray that the matter may become after 26th of November.
Under prayer of so and so. Additional Advocate
Yes.
General of Chennai, appearing for
the sole respondent, yes.
Respondent. Did the matter be fixed after?
26 of, after, either 27 or 28.
Did the matter be fixed on 28th?
Okay. Much obliged.
May I please, Your Lordship? I beg to mention item 10 and item 16.
10 and 16.
Yes, Your Lordship. If the matters may come up after 4 weeks,
On the prayer, you are appearing for the petitioner.
for the respondents in item number 10 and for the petitioner in item 16.
Lordship, I'm the petitioner for item number 10, Lordship.
Item number, you don't have any objection, right?
No objection.
The prayer of so and so. Learned counsel appearing for the respondent. Let the matter be fixed on so and so. Item number 10 and
16, the petitioner in item 16, Your Lordship.
16, same order. But only thing is that petitioner and respondent.
Please, Your Lordship. Lordship, I beg to mention item number 14 and 15, Lordship.
14 and 15.
Lordship,
Yes.
let it come up after 2 weeks, Lordship.
Two weeks after. I record his name and on his prayer, 2 weeks. You are appearing for?
The appellant.
So and so appears for the appellate.
With your obliged, Lordship.
May I please, Your Lordship? Lordship, I beg to mention item number 11 on behalf of VG Momi, Lordship. If 2 weeks time may be granted to me, Lordship.
11 also.
Lordship, I'm for the petitioner here. This case pertains to a challenge of in the form of a civil revision, and I've implemented the victim as a party. But since it was upon the state to serve a copy to the victim, this is the third occasion where the state has sought time, seeking an opportunity to serve the copy of the petition to the victim, my lord. So today, on the last occasion, a week back, time was sought, and the OC of Women Police Station, I believe, was to serve a report as to whether this copy of the petition had been serviced to the victim. And I believe since there's no report, and an inference can be drawn that the police has not been able to trace the victim's location, because the victim was not a local here.
The notice was supposed to be served to the police.
Yes, my lord.
The police report hasn't come.
Yes, this is the third occasion where no report has been produced. So, my lord knows too well that the law, if at all the victim is incommunicado, if the victim is no more residing here, perhaps.
This is respondent number 2.
Yes.
The victim.
Yes, my lord. The victim is
Victim.
respondent is the respondent
So
number 2.
police is yet to serve the notice on respondent number 2.
Yes, lordship.
Right.
Yes, lordship.
And then, then amicus can be appointed to the
Lordship,
victim.
But this is.
Is this a case of POXO?
Yes, my lord.
So amicus can be
Yes, my
engaged
lord.
if-
My prayers is that if at all the police is unable to trace the location of the victim, then since the law does not expect the impossible to be done,
That's what,
perhaps,
if
yes,
police is unable to serve
my
the
lord.
notice,
yes,
then police should give a report before this court that's, they are unable
Yes, my
to
lord,
serve the
certainly.
notice.
They were
So we'll
supposed to
call
do
for
that
a
today.
police report. We'll
this
call
has
for-
been done on 3 occasions now, where the police have been asked to furnish a report. So, my lord, my humble submission is that if at all they are unable to do so, if the legal services may be directed to look into
Then
the matter.
amicus can be.
Lordship, yes, lordship,
Then let the matter come. Let the matter come.
my lord.
Obliged.
For motion from the supplementary course list, item number 17.
Lordship,
Yes.
this is an application for bail. Lordship, the alleged accused is represented by his wife. The letter of authorization is at Lordship page 35A, annexure D1. Now, Lordship, yes, letter of authorization at 35A.
Okay.
Lordship, against Sumudu FIR dated 23/5/2029, the accused was arrested on 23/5, was arrested, Lordship,
Arrested on
24/5/2025.
24/5/2025.
Lordship.
And what is the offense?
Now, Lordship, the offense relates to, Lordship, my Lord, kindly bear with me.
What is the FIR?
Lordship, charge sheet is already filed.
Charge sheet already filed.
Charge sheet is already filed. So, Lordship, charge sheet is filed under section 142. May I give the section? Section 142.
42 of?
142 PNS. That is, Lordship, kidnapping, abduction, kidnapping in abduction, 352(2), that is extortion. Then 3082, and 352, intentional insult with intent to provoke.
This is not under this thing. The sections you mentioned,
Lordship, sections are 142,
142 and 35
352.
of BNS.
Yes,
Okay, 142 and 35. Okay,
Yes.
140 is this thing.
142 is, Lordship, kidnapping, abduction, threatening to cause death or hurt. Then, Lordship, 352(2) is intentional insult with intent to provoke breach of peace. 3082 is extortion, Lordship. Then,
So these are the charges under charge
yes,
sheet.
Lordship.
What
Now,
is the charge sheet?
Lordship, may kindly see that the charge sheet is page 30. Annexure C.
Yes.
Charge sheet is dated 3/6/2025, Lordship. And Lordship, may kindly see at page 34 that it was submitted on 5/6/2025. Page 34.
562025. Okay.
Yes.
62025.
Then Lordship, may kindly come to page 36.
Page 36.
Yes. Lordship, a bail application was filed before the Principal District Sensation Judge Bokokchong. Then on 17/6/2025, Lordship, if Lordship may kindly read the second paragraph. Since the accused was arrested on 24/5/2024, such and such, meanwhile, charge sheet has been filed on completion of the investigation. Also, since that the present accused is involved in another case, such and such. However, Lordship, my main contention was that in view of the filing of the charge sheet, his further detention may not be, custody may not be required for the purpose of investigation. So that was the ground to pray for bail, but that was rejected.
So we'll call for the case there.
Yes. Then Lordship, may kindly see at page.
But charge sheet is filed where? So session judge.
Yes.
So we'll call for the TCR and we'll consider your district.
Lordship, a date may be fixed, Lordship.
Heard Mr. Takamasa, the learned senior advocate, assisted by.
Sendilong.
So,
May I please, Your Lordship?
yes.
I'm for the PP, Your Lordship.
Yes.
I'm appearing for the state, Your Lordship.
Correct. You have anything to
The CD
submit?
can be, yes, your record can be called for, Your Lordship.
Yes, yes. So appears for the the applicant, accused applicant, the alleged PP, the so appears for the state respondent. This is an application under section 483 BNSS 2023 for praying for bail, release of bail of the accused applicant in connection with GR number 12 2025 Mokokchung PS-1 Mokokchung case number 0600062025 under section 140 in bracket 2 stroke 352 in bracket 2 stroke 308 bracket 2 stroke 111 bracket 2 bracket B, capital B, and 3 bracket 5 BNS 2023 read with section 7
NSR.
NSR Act. The state bail application has been filed by the wife of the accused applicant, being so authorized by the accused applicant who is inside the jail. The accused in the instant case was arrested on 24/5/2025 in connection with the Mokokchung PS case number 0062025 under the above mentioned sections. It has been submitted before this court that charge sheet where is the charge sheet? Page 50.
34.
The charge, page 24.
My Lord, the charge sheet starts from
Where is the charge sheet number?
Lordship at page 30, Lordship.
Page 30.
Charge sheet number 006/2025. On the top.
A
Lordship.
charge sheet, the charge sheet number 0062025 dated 303.
36.
062025 has already been submitted before the learned,
Principal and District Session Judge Mokokchung.
before the principal and session judge Mukokchung,
Lordship.
Nagaland. Let the trial court records be called for. The scanned copies of the trial court reports, scanned copies
Yes,
or
Lordship,
scanned
scanned
copies
copy.
of the trial court records be called for. Let the matter be fixed after.
Lordship, let it be next week.
Is it possible to
Yes,
come?
Lordship.
After 2 weeks, Your Lordship.
2 weeks will be too long, Lordship. Since May, he's in custody.
So he's in custody
Since 24th May.
from May. So is it possible or it's not possible to getting the TCR from Mukokchung in 1 week? Otherwise, we'll fix it
A
for 2
week's
weeks.
time, Lordship. A week's time will be more than sufficient,
Your
Lordship.
Lordship, at least 10 days may be granted. 10 days may be granted.
10 days. Let the matter be fixed after 10 days. Upon consideration of the TCR, this bail application will be considered.
So, Lordship, may kindly give us a date of 10 days.
Fix it on after 10 days, give a date.
Huh? Let it be on Monday, 10th.
10th of November. Let the matter be fixed on 10th of November for further consideration.
Much obliged, Lordship.
Much obliged, Your Lordship.
For motion, item number 18.
May I please, Lordship. Lordship, the present civil revision petition is arising out of order dated 19 August 2025, which is passed by Subdivisional Officer Civil in Appeal number 1 of 2025. Lordship, the It's in page 38.
Page 38.
Page 38, that is the imping order which is arising out of it. Lordship, in this appeal, the appeal was passed against the petitioner. So the court below in DB's court in miscellaneous case number 115 of 2025, the said court has passed without jurisdiction and with material irregularity, without considering the contentions set out and presented by the petitioner in the court below, Lordship.
So what was the dispute?
The dispute is, Lordship, I'll just cite the brief facts of the case.
So this, subdivisional officer has passed an order against you,
Yes.
and you have come before this court for revision.
Yes.
Revision
yes,
of that order.
Yes, Lordship.
And what was the dispute there?
Lordship, the civil STO, the court of civil STO has passed without considering the contentions set out by the petitioner in the court below, which is passed by DB's court. Lordship, I'll just cite the brief facts of the case. On 10th March 1984, I bought a land in the place of Junga Choken Pentenjon. That is a place which is located in the Tsiminyu village under Tsiminyu district, one of the district in Nagaland. And I have bought, the measurement of the plot of land consists of 5 tins in the west. It's there in the map, but just for the sake of a flow. And 5 tin in the east. And I paid 25,000 to let Mr. Sotilo. Lordship, Sotilo is the father of present respondent number 5. And in Nagaland, since in those time, only the oral practices was happening, so as a fulfillment of the customary practices, I informed the late Mr. Sotilo's parents whether they have any objection of my buying of the plot of land, the said plot of land. Then they said there is no objection both now and even in the future. And so with that, I've bought it.
So you paid the money and you bought the land?
Yes, I paid the money and I bought the land.
But there was no agreement?
There was no written agreement.
Correct. Then?
But Lordship, in Nagaland, I will, but let me just continue. And so after I bought the land from Mr. Let Sotilo, I let out my plot of land to 4 families. 4 families. I let out so that they will cultivate.
You let out that land to 4 families?
Yes.
Correct.
So that they will continue under my permission, with my permission. And so.
How much land was that?
Lordship, the land consists of 8 tins.
8?
Tins, Tins. Now,
tins.
tins, if we convert it into bigas, it is 1 tin is equivalent to 1.5 bigas.
Okay, it's something around, so 8 tins means something else, more than 8 bigas.
Yes, yes.
Correct.
And so that is the measurement used here in
So
those
you let
times.
it out to 4 families to cultivate there?
West part. In the west part, I have 5 tins. And so in this
No, the whole plot of land you have given for cultivation, correct?
No, I bought 8 tins, but
Correct.
I let out only 5 tins
5
to
tins, okay.
4 families.
Right.
So the names are Rusuvulu Tep, Ronga Tep, Rungulalo Tep, and myself. That is 4 families
So
included.
there are parties here in this case?
They are not parties.
There are not parties, okay.
Just I'm
so,
letting
so
out.
for 4 families, including your family?
Yes.
So you have given, 5 teens to 3 families to
Yes,
cultivate.
yes.
And the remaining 3 teens, more than 3 teens, you kept
Just
for
I'm
yourself?
keeping it for myself.
Yeah, you kept for yourself and you started cultivating.
Yes, we
Then
cultivated.
what happened?
Then, usually June cultivations is for 10 years.
Usually?
10 years.
10
years,
years.
Lordship. Yes, because that is a shifting cultivation or either.
So 10 years they do the cultivation there?
Yes, cultivation.
And
They will.
then after that, they can go to a different place?
Yes, because.
Because the land becomes infertile, something like that?
That is the practice. One of the scientific way of doing it is also because in a place where we cultivate, that needs to again
Correct.
rejuvenate itself. So we choose another place to cultivate. In the meantime, those already cultivated land
So
will
that
grow.
is the custom here in Nagaland?
Yes, that is the
But
practice.
usually the Zoom cultivation is done for a stress of 10 years, then they shift
Yes,
to different place.
yes, Lordship.
Then they keep this land vacant so that like it can get its own this thing.
Yes, Lordship.
Yeah.
So for 10 years, I have let out my plot of land in the west part, 5 teens to 4 families. And these families are actually my
The 4 families or 3 families?
3 families, including
families,
me, yes. So they are my relatives, my cousin brothers. And so with the understanding that since we are relatives, they don't need to pay me any land rent. And so they cultivated like that.
So they didn't pay you anything?
They didn't pay me anything.
Okay.
Yes, because
Nothing,
I just allowed them to do
nothing
that.
in kind also. I mean,
No kind, but with my permission, I let them to cultivate like that for 10 years. I let out to them again another 10 years, so 20 years, Lordship, from 1984 to 1994, and from 1994 to 2004 for 20 years. Now, in the meantime, during the time between 1984 to 2004, in 1994, Lordship, this is very important. Youth department came and requested me if they can cut some firewoods and they would utilize that wood. And so I allowed them. Then the youth department came.
Which
and
department?
Youth department, church.
Youth department.
Youth department means it's a department where in the church, in Semenyu area, they work for the church. And so they requested me to
So is it a part of any government department?
No, that is not government department. Just
So it's a kind of an organization.
it's I would not say exactly organization. It's a church. It's a church base where they volunteer themselves to work for the church. And so, being appointed from the church members, the youth department requested me. So during those time, Pastor Sotilo Tep requested me, and so I allowed them, Lordship.
Allowed them to cut some trees.
To cut some firewood for their own use. Now, after 2004, again, now for 20 years, I let out this land to 3 families. Now in 2004, I let my plot of land to one person named Latrong Kent.
Which portion of land?
That same
That
5, yes.
3 teens that you have kept.
No, 5 teens.
So the other families, they have gone out.
When I let my land to other, that means the family who have already cultivated, their tenure is done. Their tenure is finished from 10 years, another 10 years, 20
So
years.
20 years they have completed, so after that they have gone out.
Yes.
So you have not let the land be cultivated by them.
Yes.
So you have given it to somebody else.
Yes. So that somebody is Mr.
For the whole land, for 5 teens.
5 teens in
5
the
teens.
west part.
So you have given it to somebody else.
Yes,
Correct.
another person. And Mr. Latrong Ken, since he is not my relative, he's just my village person, and so with my permission, he cultivated, and so he paid me 100 rupees as land rent
For
utilizing my plot of land.
yearly basis or what?
For just one tenure, that is 10 years
10
of
years,
cultivation.
100 rupees for 10
100
years.
rupees. That is actually not even equivalent to the market value, but with an understanding, since they are cultivating my land as a...
So you have given on rent for 100 rupees for 10 years tenure.
Yes. So, during that time from 2004 and following years, in 2004, 2 persons, they came and requested me again by the name Francis Tep and Kenyu Hunlo Tep, 2 persons. And so they came and they requested me if they can collect firewood again. And so I allowed them, and they cut some firewood. Then in 2005, on the next year, another 2 persons came, Yun Tilo Tep and Ato Ken. So, Lordship, why I am citing all these persons who have utilized and all those things is because in Nagaland, the practices in the village is in the oral tradition. And so, any person who brought a land and who utilized a particular plot of land and he used it more than 3 years, that person is considered as the landowner. recognized by the community because it is happening before the knowledge and before the eyes of all the village community. Now, village is a very small place.
So
It's,
if somebody cultivates the land for 3 years,
yes,
then he's be termed as the owner.
he is considered as the owner. That is the customary practices. Lordship, according to Tsemenyu, but in Nagaland, those customary practices is also not just legal, but it is a constitutional standing, which is recognized under Article 371A, Lordship. And so, I bought it, and these are the people, they also recognize that I am the owner. And village community knows, everybody knows that I owe this land, and they are also taking permission from me, and they are cultivating, and I let them out, and they recognize, which means the whole village community knows that I have bought this particular plot of land from late Mr. Sotilo, and I own it, I'm utilizing it, and as a recognition of my ownership, people are coming and taking permission from me. So that is the thing. Now, after long years, in 19 January 2024, Lordship, respondent number 5, he filed.
Respondent number 5 is the son of the original owner.
Yes, Lordship. So, respondent number 5, he filed a defiance order dated 01 September 1994.
What is defiance order?
Lordship, can you kindly turn to me to page 19, Lordship?
Page 19?
Yes.
Yes.
In my petition. Allow me to read for you, Lordship. To the Chairman, Tsemenyu Village Council, Tsemenyu, Nagaland, subject, submission of complaint to Deputy Commissioner's Office for defiance of government order and repeated violation in connection with DB's order, DB's court miscellaneous case number 23-9 of at Pentagon by Sri Lokebu. Sri Lokebu is my name, although some spelling is.
Where is this order, the DC's order?
Lordship, this is.
DB's court miscase?
This DB's court, even me, I am hearing on just last year, January 19.
Okay, when this was filed, you got to know about this?
This actually, that is the issue, Lordship. So allow me to just explain this.
No, what I am asking is that like this DB's court miscase number, whether it is there in the record?
It's not in the record.
Not in the record. So you were not aware of this?
Not aware.
Not aware of this. You got to know when this was filed before the check?
Yes, Lordship.
Okay, so you then what was the content you read?
So it says, in continuation, Sir, with due respect, I would like to inform you that related to the above cited subject, all effort on my part to settle things amicably with Sri Lokebu for his defiance of DB's court order. The letter says that I have
correct, they had failed.
Had failed and am left with no option but to refer the matter to higher authority as the matter has been dealt with by them before while and my late father Gauhati Thong was alive, Lordship. I am doing this in good faith with a request to your kind authority to look into the matter and see whether the decision of district administration came up with his adhered.
Who is this Samuel Thong?
Samuel Thong is respondent number 5, Lordship.
So his father was Gauhati Thong.
Yes, Lordship.
So Gauhati Thong, you bought it from Gauhati Thong? No, or his father? Grandfather?
Your Lordship, sorry, grandfather.
Grandfather?
Yes.
Grandfather name is?
Sotilo.
Sotilo.
Okay.
So Sotilo is the grandfather of Samuel Thong.
Just one minute. Lordship, Sotilo Kent is the seller of the plot of land.
Sotilo
Now, respondent number 5 also bought claims that they also bought this land from Sotilo Kent. And I am also claiming that I bought this plot of land from Sotilo Kent.
But all throughout the land was under your possession?
Yes, Lordship.
That is your claim, right?
Yes, Lordship.
Yes. So, now DB, what is that? What is the DB order or whatever? Yes.
That DB's order is not there. They have not been able to produce the actual existence of this 23 of 92. They are just saying that
Page 23?
I have defied. That is not their lordship. So just allow me to continue with the things narrative. And so after they filed this defiance letter, this was sent one to Deputy Commissioner, another to Simenu Village Council. So
Village Council, okay.
yes, another to Village Council. So I came to know from there. And so I make an inquiry. I was not there all this time, and there was no such case that has been decided, and no service has been served upon me. So with the curiosity, I search.
Okay.
And I inquire all the appropriate authorities during the time, who was the DB, who was the person in authority. And so, Lordship, kindly come to page 21, annexure number 2.
What is page 20?
Lordship,
Page 20, what is this?
page 20.
This is another letter submitted to DC.
Yes, same. So I'm not.
Correct. Now
same
page
thing.
21, yes,
Page
head of
21.
DB.
So after
What is head of DB?
After I met
DB means?
Head DB means who is the in village there is a DB who adjudicate the case.
DB
that
means what? DB means what?
Dubashis court.
Okay.
So
Dubashis court,
Dubashis are a legal entity recognized in under village lordship. So after I make inquiry,
Who is Asomag?
Ashomak is the head DB during the time when the respondent number 5 was claiming that the DBs has issued such order, and then I have defiled, I have violated those DBs court. And so
Asomag has written this to whom?
Ashomak has written to head DB, Deputy Commissioner Office.
Asomag is, he himself is the DB, isn't it?
No, he was the DB back then.
He was
Head DB.
he was a former DB.
Yes, former DB.
But he is writing this thing on behalf of you.
I requested him, I inquired from him.
But he's not holding any post.
Yes, he's not holding any post, but since he was the head DB during the time when the respondent number 5 is claiming that the DBs has issued this order.
Okay, okay. Then what about?
And so, after I inquired him, he explained, no, there was no such case decided like that. And so, in order to clarify, he has written this clarification letter to Deputy Commissioner. And so, allow me to just read this letter, Lordship.
Yes.
I'll just begin from, Sir, with due respect, I would like to state that in my name has been incorrectly associated with the aforementioned case. So in that case, his name has been mentioned, Lordship.
Okay.
I would like to bring to your kind notice that I have no direct or indirect connection with the parties involved or the subject matter of the case. It may be mentioned here that the duty detailment of DBs to the spot for demarcation of the land dispute dated 13 January 1994 was signed by then DBs Picato Kat as the head DB. Whereas, in continuation, and whereas I was the head DB during the period which makes it suspicious document. Lordship, in the land demarcation order which was issued against me, there
It was signed by somebody else.
Somebody else, whereas he was the head DB back then during the time.
Yeah,
when it was
Asomag was the DB, but somebody else has signed the document.
Yes, Lordship.
Correct. Then?
I would like to draw your kind attention towards the fact that as you go through the affidavit and the DB's court judgment order dated, you will find that nowhere in the document is my signature. His signature is not there appended. Rather, it is signed for on my behalf. Therefore, I would like to reiterate here that...
Okay, I got it. Yes, then?
Lordship, so after the clarification has been given from them, I met an...
No, where is the clarification?
Clarification letter is 25, page 21, just...
The 21 is what this person has written to him.
Written to DB. So that is one clarification. So
Okay,
after...
one clarification, and then?
One clarification. So I got to know that there is an ulterior motive from respondent number 5.
That's fine. I mean, that's fine. Now, then what happened?
And so, Lordship, kindly come to page number 22.
Yes, 22 is DB's code.
Yes.
Yeah. Additional Deputy Commissioner.
So, Lordship, the type copy is on the next.
Yes.
And so here, This document was passed in
94.
14 January 1994, but the seal and signature of the magistrate was appended only on 4th August 2005, after the lapse of 11 years, Lordship.
How do you know this?
Because it's there on the bare perusal of the record.
482005.
Yes, Lordship.
But this may be a certified copy. How do we
Lordship,
know
but that is one suspicious, and that is not only the thing, but DB's Picato, as has been said in the earlier clarification letter in page number 21, where DB's Picato had the DB as the head GB, whereas Ashumak was head of the
So
GB.
basically contention is that at that point of time, Asuma was the DB, but he hasn't signed it document.
Yes, he has been-
Somebody else has signed on his behalf.
Yes,
Correct,
Lordship.
that has been clarified. Now, what is this document of this page
So,
23?
okay, that is, Lordship, I think you got it, this portion.
No, I got it. Now, please tell me what is page 23?
Page 23, I wanted to bring to this honorable court's notice is that this has been passed in 14 January 1994, but the magistrate on signature of magistrate was like
This
that.
is the document or what? This is the document
Yes.
which you are impugning.
That is not the document, the
Now,
actual.
what is the, let us see what is the document in connection with DB's court's miscase, where in connection with DB's court miscase,
Number
where number
23,
so and so, Sri
Chonbu DB's question is saying
detailed to the spot for demarcation of the land.
land division, Lordship.
Then detailed DBs went to what is detailed DBs?
DBs after usually.
Detailed, one second. Detailed DBs went to the spot on 13 January 94 and made demarcation. Location so and so, not zooming land. So this is the land.
Yes,
The
Lordship.
land has been divided among small reach of division boundary, touching Sri Sanchin King Jungling land from so and so, Western division so and so. So some demarcation has been made.
Yes. So usually in the DB's court, they will decide the
So
dispute.
spot verification is done and some demarcation has been made.
Yes, yes.
Correct.
Yes.
So this is your land, right? That you're
This is
claiming.
my land,
This is
yes.
you're
Yes, Lordship.
claiming. So what is the outcome of this?
So they are saying that these DBs has already decided the case. There was a existence of case, which I am not aware. And they say that DBs has gone to the spot and they have detailed, they have demarcated. And
How demarcation? I'm not understanding how demarcation is made.
Lordship, usually,
No, this only says that location Jung Tokshen, correct? Now north is somebody's land, south is somebody's land, east is somebody's land, west is somebody's land.
Lordship, the plot of land is, the measurement of the plot of land is 8 tins.
Correct.
5 in the west and 2 tins. Now when this demarcation is done, the DBs, what DBs would do is they would say on the north side belongs to that person's land, just to make the imaginary line.
No,
On the
but
south,
what this court is asking, by this DB, whether any dispute has been resolved, whether they have declared that this land is yours or this land is his, they have not done so.
They have not done so.
They have only demarcated the land.
Yes,
So
Lordship.
this is the land.
Yes, Lordship.
And that has been done on the basis of an application filed by the defendant. Correct?
yes, yes,
The
Lordship.
person, what is his name?
Samuel Thong.
Samuel.
Yes, Lordship.
Yeah, on an application filed by or a complaint filed by him,
Yes,
a
Lordship.
demarcation has been done.
Yes,
and
Lordship.
you were not aware of this.
I'm not aware.
But the DB that has not decided as to who the land belongs to whom.
Yes, Lordship.
It hasn't been decided.
Not decided.
Not only the demarcation has been done,
Yes, yes.
but they have not decided whether the land belongs to Samuel Thong or the land belongs to you. Whether they have done so.
Lordship, their claim is there was a case in.
So they have said that this is my land.
Yes.
And there is some dispute or whatever, they're about the boundary. So you please demarcate this land. That's what that's what the
Yes.
application.
Yes,
correct?
Lordship.
So according to that, they have, the DBs has demarcated it. So this is your land. That has been decided.
Lordship, just one.
Correct, correct. You take your time. Yes.
What they are saying in this demarcation is there was a case decided, and that according to that judgment, this measurement should go to that party, and this another boundary should go to that party. And so, in order to ascertain that demarcation, certain DBs has been entrusted to go to the spot and detailed.
They have gone there and they have demarcated it. Correct.
Yes, and so they are saying that the case has been decided against me, and I am not.
No, where that has been stated? That's what I wanted to know.
Yes, even me. That is the very blurred line where respondent number 5 is claiming, Lordship. So.
Okay, then after it, what happened?
Lordship.
Then this demarcation has been done. Page
After-
23. Then page.
Yes.
What is page? What is this? 1st September 1994 letter order.
Lordship, again, kindly come to
Dispute
page number 24 and 5.
Logobu tape is you, right?
Loco Butep is me, Your Lordship.
And this Guai Thong is like Samuel Thong's father.
Yes.
The parties in the instant case have signed and consented on the judgment order given by DBs. The judgment order number Miske so and so dated pronounced by customary court so and so sells stand.
Yes, Lordship.
So the additional deputy commissioner has stated that you were party to that. And
Yes.
you have signed that document.
Yes,
Correct.
but whereas I do not know.
But that is your claim. Huh?
Yes, yes.
Now this letter has been issued by the additional deputy commissioner. So Sri Logubu Tape, who has cultivated kheti in violation of the customary DB court order, is hereby ordered to pay some so and so to so and so as land rent for 1 year. So this, whether this has been challenged?
Lordship, I have challenged the order.
Yes, let us go
Lordship.
one by one. Then
So, Lord-
this
Lord-
order was passed. Then what happened? 94
Lordship,
order.
please come to page number 24.
Page number, no, page not 24, we have gone. What is there in 24?
So here, in DB's contempt court order here, as I made inquiry,
No, page 24 is type copy or what?
page 24 type copy is in 25, Lordship.
That's I have gone through, no?
So, in
No,
the,
this I have gone through. That
Yes,
additional DC has
just-
passed an order.
Lordship, I wanted to just show to.
No, I
my
have seen
Lordship.
it. Like, I mean, I have gone through it.
Okay,
I have just now I have read it.
Lordship.
That the additional DC has stated that there was a dispute between Logubu Tape and Gaongi Thong. Correct?
Yes.
And this order was passed, and there was a signature of you also
Yes.
in that document, and thereby you have been held that you should pay rupees 50 as fine because you have unauthorizedly you are cultivating there.
Yes.
That was the order passed by additional DC, right?
Yes,
So whether this order was challenged by you?
No, I have not challenged that.
Then-
But Lordship, in this order, there was 2 persons' name was attached, Chonbu and Guasheni. Guasheni and Chonbu name was attached at the end of the
In the
order.
court of customary court of Senmu.
Siminyu, Lordship.
Senmu,
So here, these 2 persons whose
No,
name
you
has.
tell me one thing. The dispute case between Logebu Tape and Guangi Thong, correct?
Yes,
So you are Logebu Tape,
yes, Lordship.
and Guangi Thong is the father of respondent, different number 5.
Yes, Lordship.
Respondent number 5. The parties in the instant case have signed
Yes,
and consented on the judgment given by DBs.
yes, Lordship.
So which was the judgment?
Judgment-
was the miscase.
Yes, miscellaneous
Miscase,
case.
that was the judgment.
Yes.
So there is an allegation that you have signed there.
Lordship, they have-
Wait, let me explain. Signed there. The judgment order number miscase 23 dated pronounced by the customary court of so and so.
Yes, Lordship.
So in that judgment, what this reveals that in that judgment you have also consented to.
Yes.
Correct.
That is their claim.
Now, Logebu Tape has cultivated the kheti in violation of the judgment. So, in spite of that judgment, you have been cultivating there. That is their allegation. Correct.
Lordship.
Judgment that in violation of customary DB judgment, and he is by order to pay rupees so and so only to Gaomi Thong, and Gaomi Thong is the defendant.
Yes, Lordship.
as the land rent for 1 year of 1994. So 450 rupees was asked to be paid. So this was the order passed by the additional deputy commissioner, who is Seminyo is a place or what?
Seminyo, it's a district.
It is a district.
One of
yes.
the districts.
So district deputy commissioner who is authorized, so he has, with his authority, having jurisdiction, has passed this order.
Yes,
correct.
Lordship.
Now, what have you done to this order? If you think that like this is not correct, whether you have challenged this?
Lordship,
Because you were not aware. That's what you are saying.
I have not impugned the present order, but their claim is.
Okay, now let us go to the other documents. Now, after this, what happened?
So, Lordship, just before we move on, this document, 2 persons' names were attached.
What?
And when I inquired,
I could not see any names.
at the end of the document here,
What is his
copy
name?
to Sri Gauhati Thong and Chonbu.
These are two people. I mean, one is you and one is the.
So 2 persons whose name has been attached here, I made an inquiry to them because they are still here.
Who? Gauhati Thong.
Gauhati Thong, yes.
Gauhati
And
Thong is the dependent
no, Samuel Thong is the,
father, na?
yes.
Samuel Thong's
But
father is Gauhati Thong.
no, Lordship, Gauhati, that is another person.
One
And
second.
Chonbu.
One second. It's a dispute between Lagubu Tap and Gauhati Thong. And copy has been given to Gauhati Thong. See, the dispute was between Lagubu Tap and Gauhati Thong. And copies have been given to them only.
Yes, Lordship.
Then who are the other people you are talking about?
Lordship, in page number just.
Okay, now what has happened what happened in 2024?
Lordship, so I'll satisfy this court later, but in this case, and so I made an inquiry to 2 persons whose name has been appended in the order that has been passed, and so they say that.
But I don't see
They were
any
not
other
aware.
person's name. I don't see any other person's name.
Really, okay. Lordship, so I'll just come to next one. And so after I make an inquiry, there is a high suspected that these documents are either manipulated or they have violated natural justice by not
Okay, you
letting
got
me.
to know something, then what happened?
Okay. And so I filed first complaint letter.
Before this village council?
Before Deputy Commissioner. Lordship, my first complaint letter is in page 28. 28.
28, okay. Now, what is this letter? What is this 31/8/2024? Type copy? What? Type copy of what?
Lordship, page 28. Page 28.
No, what is page 26? I'm asking what is page
26.
26?
This is Seminyo Village Council's one of the body legal.
Correct, that
entity.
you have approached this council.
Lordship, I'll come to that. But just
Why you are coming later on? You tell me whether you have approached this.
yes, I have approached.
Then what happened?
So before I approached
Okay.
this village council, I made the first complaint
Then you
letter
have
to
wrongly
DC.
annexed this document before this, because we should annex those documents synchronously, I mean, seriatim,
Okay,
according to the date. But you have to annex this document. This is a document dated 31/8/2024.
Okay, Lord.
But this has happened in May.
Yes.
You have written to the deputy commissioner in May.
Yes.
Correct? Yes.
Yes.
Let us go there.
So, Lordship, in this complaint letter, page number 28, I have written to Deputy Commissioner saying that subject request to nullify the unfair judgment of DB's court miscellaneous case number 2392 at Pentagon referred in Samuel Thong letters dated so and so in the defiance letter.
So you have explained all these things,
Yes.
and you stated that secretly passed in your absence, right?
Yes.
DB's order was passed. So you
Lordship.
were not aware of this. and you have explained the facts, correct?
Yes, Lordship.
So what the Deputy Commissioner has done?
So Deputy Commissioner, so far, he has not taken any step.
But he has issued a summons.
No, that someone is different. And so after I filed this one, no action has been taken by Deputy Commissioner.
Deputy
Lordship.
Commissioner, okay, then,
Yes.
then
That is why I approach
the village council, Panchayat
yes.
Court.
So on 31 August 2024, I approached Simenu Village Council.
Okay,
And Simenu Village Council has summoned both respondent number 5,
so
myself.
this is the summon.
Yes. No, that someone is not the one.
This is
Lordship,
different.
page number 26.
Page number
26. This is the judgment of Simenu Village Council.
Type copy is page 27.
Yes, Lordship. Type copy is page 27.
So that is the order dated 31/8.
Yes, Lordship.
So what was the order?
So the order, after calling both the parties and they have considered, they say,
So let us go to the operating part.
okay.
According to the customary law,
According to the customary law, when any person purchased land from anyone and cultivated it for 3 years consecutively with no issue or problem within that period, then the land belonged to him or her. So basing on the customary law, the village court made a judgment that the land at Njunga Chokesen at Pentejon will be given to first party, that is Sri Lokobu, myself, Lordship, son of Sri so-and-so from Semenu village.
so it has gone in your favor.
Yes, in my favor.
Then what happened?
Lordship, just one
You answer what
important-
the court is asking. You just tell me what has happened after.
Okay. Lordship, so after this judgment is passed, instead of being abide by the judgment that has been pronounced, because the Semenu village order is same
I
as...
understood. Yes, order has been passed in your favor. After that, what has happened? You just tell me.
After that, again, respondent number 5 filed another complaint letter in the DB's court.
Where is that?
That is in page 29.
Page?
29, Lordship.
Page 29.
That is the summon letter served to me. So when this summon letter was served,
Correct.
I protested, since this case is already decided by
No, okay, like
the,
summons was issued, then.
then another, on the first summon, the issue could not be settled, Lordship. The issue could not be settled.
First summon was issued, you went to the.
I went,
You went
they
to the
also
DB's
came,
court, huh?
yes.
Yeah, they also came, it was not
But
decided.
it could not be decided.
Then what happened?
And so another summon was issued.
Another summon was issued, then what
Yes.
happened?
Then there was a hearing, and hearing was to be declared after 15 days. The judgment of the DB's
So
court
hearing occurred.
occurred.
Hearing occurred and judgment was to be passed by the this thing, DB,
Yes,
right?
yes, Lordship.
Then what happened?
Then in the process, earlier I filed first complaint letter to the Deputy Commissioner to nullify the order that was passed.
Nothing was done at that point of time.
Yes,
Then what happened?
but the first complaint letter was pending in Deputy Commissioner office. So since Deputy Commissioner did not dispose that case,
So then he went to the village panchayat.
no, I filed second complaint letter to Deputy Commissioner.
Okay, then
So when I filed second complaint letter to Deputy Commissioner, saying that please review the judgment that has been passed, because I was not aware of the judgment that has been passed
that
back
was
then.
that was the earlier order. DB 23 you're talking about.
Yes, yes.
Now what happened? Then
So in the meantime, the impugn order dated 10 March 2025, the DB's court pronounced the judgment. And that judgment has totally reversed the first order passed by Tsimini
correct.
village.
Then what happened?
And after Tsimini order DB's passed, I found out that there was material irregularity.
Okay, that has gone against you. Then what have
Yes.
you done?
So I appealed to civil SDO civil,
Okay.
and on 19 August 2025, Lordship,
19 August.
2025,
Where is that?
page 38, Lordship.
Page 38.
Yes.
Yes, you have approached this court.
That I have approached that court. Yes. No. This is the court of civil SDO under Rule 31 for the administration of justice invoking appellate jurisdiction, appealing against the order.
No, where is that? Page 38.
Page 38 is the order passed by civil SDO, Lordship.
Correct. So you approach civil SDO.
Yes.
After that, the DB's order, which
Against
has gone
the
against you.
Against the DB's order.
Where is the DB's order?
DB's order is in page 36.
Page 36. Okay. Page 36.
So against this judgment, I appeal
So
to
this is
DC.
this was the DB which was the authorized DB at that point of time.
Yes.
There is no irregularity in that. See, there are two DBs you are talking about.
Yes.
One DB said that has given an order in favor of you.
No. Zemenu Village Council has passed in my favor.
As a civil village council is a different thing.
Yes.
And DB is a different thing. Which
Yes.
is authorized authority in customary law?
Lordship, that's why in Nagaland, both DB's court and village court has the same authority. They fall into the same rank in the hierarchy of the court, Lordship.
Same hierarchy.
Yes.
And this one village council has given an order in favor of you.
Yes,
And
in
that
my
was
favor.
not abided by the other side.
Yes, Lordship.
Then they have approached this thing, the DB.
Yes, Lordship.
And then in that DB, summons was issued, you also appeared. Then after hearing both the parties, the DB has passed an order
against.
which has gone against you.
Yes,
And
Lordship.
against that order, you have approached this
Civil SDO.
the civil SDO.
Yes.
And civil SDO has passed an order in against you.
Yes. That's why
that civil SDO's order you have challenged by the civil revision. By
Yes,
the civil
Lordship.
revision.
Yes,
That is
Lordship.
the case?
Yes, that is the
Huh?
case, Lordship.
Okay. You are appearing what?
Yes, I'm appearing
You are appearing for whom?
for the state is common. For the state.
How state is involved?
Your Lordship, because the SDO civil has passed the order. So that since they are impugning the SDO civil order, so the state is involved.
So we'll issue notice, nothing else.
Lordship,
So you
If
took,
this
you took
honorable
so,
court may-
so much of time to make me understand. Anyways,
Lordship,
that's fine. I also
thank you for
got to know
patient hearing,
something.
Lordship.
But only thing is that in this case, nothing else can be done other than issuing notice.
Lordship, if this honorable court may kindly pass the interim order,
The
Lordship,
interim
to
without
stay,
hearing
to
the
stay
other
the,
side, without hearing the other side.
because the respondent number 5 has altered the
Lordship,
present status of
See,
the
there is a valid
property,
order
Lordship.
passed. There is I mean, it's not that it's, is it without jurisdiction? No. There is an order passed by this court.
DB's court.
I mean, subdivisional officer who is empowered and having jurisdiction. He has passed this order. What is wrong in this order? Is there any apparent error in this order?
Yes, Lordship.
What is that?
Lordship, in
You show me something which is really, I mean, really an apparent error, or
Yes.
a mistake, or he has gone beyond jurisdiction.
yes, Lordship. In page number 12, if Lordship
No,
may kindly
page number
come.
12, why? He just show me from the order. Is there something which is really something
Lordship,
which he has passed this order without considering the facts, or something which he shouldn't have considered?
Yes.
The material fact. You show me from the order. Where is the wrong?
So, Lordship, I have appeal in civil SDO civil under Rule 31 of Administration and Police in Nagaland Act 1937, and according to that rule, the civil SDO, when appeal is made before him, he have the power either to affirm the order as its own or issue fresh de novo, fresh trial, Lordship. But here in this case, civil SDO, rather than either affirming or issuing a fresh de novo, he has quashed the new order, Lordship, which is beyond his jurisdiction, civil SDO, Lordship. And there is a material.
But you have challenged the order of that DB.
I have impugned both civil SDOs and DB's court order, Lordship.
Yes, so I mean, both the matters are hard to, taken up together.
Yes, Lordship.
Correct, you cannot impugn that.
So, okay.
No, you cannot impugn that village councillor's order because that is in favor of you. You may have stated about that order, but you have not impugned that. How will you impugn that? Which has gone in your favor?
Lordship, even there is a
No, you show me something.
statutory requirement under Rule 57, Clause 3 of rule of the said rule.
Okay. Well, we'll issue notice. Let's see, and we'll stay this.
Okay, Lordship.
Then we'll hear it.
Lordship, let the interim be considered on the next returnable date.
No, let it be because see, there is a which I can find out.
Lordship, there is a reason.
You tell me one thing.
There is a reason why I'm saying this, my lord.
You tell me one thing. Whether this village council and the DB
Yes.
has equivalent power or not.
Lordship, village court, the village court, if any of the decision passed by the village court, if any of the parties is dissatisfied with it, they can come to the DB's court.
Show me that law.
Lordship, that I don't have that with me, but your lordship, I as per the rules that have been there invoking.
No, correct. So I want to only understand if the village council has passed an order.
Yes.
Then you are submitting that if a village council has passed an order, then that order is appealable before the DB, correct?
It can
be challenged before
It can
the
be
DB,
challenged before the
DB. Now he is submitting that these two courts are the equivalent courts
Yes.
in the hierarchy.
Yes.
And if that is so,
Yes.
how come one court's order can be just can be ignored
Lordship,
by the subdivision law? What is this?
Lordship, that is about the case referred to. Both DB's court and village court are same in
It
hierarchy.
is there where you show me the page.
Lordship, paragraph 20.
Paragraph.
20, Lordship.
It is not disputed that DB and village council both are lowest rank of the decision maker in administrative justice in the state of Nagaland. They have a concomitant power with regard to civil and criminal case in district. The appellate forum from the decision of DBs and village council is DC ADC. It has been clearly stated.
Lordship,
Yes, Lordship.
The only thing I wanted to point out is this, your lordship. The village systems in Nagaland is a complex one. The village of the private respondent here and the village of the petitioner are different. Village of the private respondent and the village of the petitioners are different. They are not from the same village.
Okay.
Every though we are from the same community, every village
Has their own
practices.
village council.
Yes. And the village councils which has passed in favor of the petitioners
Is from his own village.
is from his own village, where your lordship,
And the other
no.
other DB?
DB is common for a particular district. A DB's court is there. A DB's court is there. So if
in one district there is only one DB.
yes, well, a DB court is there.
DB
Your lordship,
court is
if both the parties are from the same village.
Let me understand one thing. In the village council, village council, both the parties were there?
Yes, both the parties were there.
Both the parties were there?
No, both the parties are not there. Your lordship can kindly refer to page 26. There's the signatures of the private respondent is not appended.
Page.
No, 26. These are not my document. These are his document, your lordship.
No, Lordship.
Now this has been filed on oath by him. I cannot
Yes.
disbelieve this document.
Yes, therefore
Now-
there is no signature.
Therefore, page.
26.
Page 26. Page 26.
Number 2, defender. Last para, number 2, 1, 2. Appellant signature and defendant.
But both the parties are present.
No, your lordship.
Lordship, second paragraph clearly says that both the parties were present.
In the court and were given chance to deliver their speeches, and the
Yes,
court,
everything was done, Lordship.
judges and elders. This hasn't been challenged.
No, your lordship.
This
Lordship, it's
hasn't been
clearly-
challenged by him.
On the bare perusal is clearly
If
written there.
he was not present,
Yes.
his sign was not there.
Yes.
Why this was not challenged? Which has gone against him?
No, your lordship, that is for the private respondent
No,
to
that's
say.
what, so that is why we have considered it, and
Yes.
I found out that this court is prima facie finding that this this order of the village council, Taminhu village council Pansayat court
Yes.
should not have been discarded just like that.
Lordship,
Yes, Lordship.
the only thing I would like to say is
Now,
that
only prima facie, see that this matter will be considered again.
Yes.
But this judgment specifically says that like, this is not disputed that DB and village councillor both.
No,
they
Lordship,
are
I understand.
similar.
I understand, Your Lordship. I'm not against the issuance of the notice. Your Lordship, I just don't want a wrongful order to be passed. This is the reason why I'm objecting. Your Lordship, as far as they are invoking Article 30, Rules 31 of the Nagaland Police and Administrations Act 1937, the same rule, in the same rules, Rule 29 clearly says that any decision given by the assistance of the Deputy Commissioner, appeal will lie before the Deputy Commissioner. And decisions passed by the Deputy Commissioner, an appeal will lie before the High Court. This is a decision given by the SDO Civil, which is an assistant to the Deputy Commissioner. So now the appellate authority is the Deputy Commissioner. I just wanted to point out that.
Oh yeah, there is a provision of appeal also.
Yes. So appellate authority is the Deputy Commissioner.
So
I just wanted to point it out.
Show me that, where is it?
Lordship, Nagaland, page 37,
Page 37.
Rule 29(1).
Rule 29,
1.
page 37.
37, here.
Rule 29 1. Okay.
If I may be allowed, just one.
Yes, please.
An appeal shall lie to the Deputy Commissioner against the decisions of any of his assistant and to the High Court against the original decisions of the Deputy Commissioner, if the value of the suit is such and such, or possessions of immovable property. I just wanted to point out that, Your Lordship, the less I leave it to my Lord.
No, your duty bound to point it out to me. You are an officer of court.
Yes, my Lord. So I just don't want this court to pass a wrong order.
Absolutely. I want your assistance because I'm not aware of all these things. So
Lordship.
you'll have to point me out.
Obliged.
In the court of the subdivisional officer, civil in the court of the subdivision, so he is the SDO.
Yes, he was an assistant to the Deputy Commissioner.
SDO, so he is the inferior officer to the DC.
Yes.
So there is an appeal provision.
Yes,
to the DC.
there is an appellate authority.
He hasn't gone there, and
No,
directly he has come to this
here. And there's no provision to come directly to the High Court.
So,
Only when
your submission will be this is not maintainable because there is an alternative remedy.
Correct. So if any interim is passed, Your Lordship, then this court is exercising beyond the jurisdiction, my Lord. That is
An
just
appeal shall lie to the Deputy Commissioner against the decision of any of his assistants and to High Court against the original decision of Deputy Commissioner if the value and so and so. Yes, what do you have to say on this?
Lordship, as has been presented here, my only prayer is that in the present case here, the respondent number 5 has already altered the status quo of the property in dispute, Lordship. He has started leveling it, clearing the shrubs, intending to build either...
We should have approached the DC.
correct.
Why you have not approached the DC? See, there is an appellate provision. And since there is an alternative remedy already there, so how you keep, I mean now this petition becomes not maintainable. So you could have got speedier remedy from the DC.
Correct, Your Lordship.
And this order was passed on 19th August 2025. You have approached this court so late also.
And that too, Your Lordship, challenging a 1994 order, Your Lordship.
No, he has challenged this also, no?
This also.
Okay. That order he hasn't challenged. One order, that original DB's order, 1994, that he hasn't challenged as yet. That has to be seen. Because obviously he has gone to this thing, that village council and all, in a very delayed stage.
Yes, this writ petition as it stands, Your Lordship, is actually non-maintainable at all. So I'm, Your Lordship, leaving it to my Lord.
I'll have to dismiss this. I appreciate your effort, but this court cannot exercise the jurisdiction where there is a special statutory remedy.
Yes.
It's not, something that which has not been provided in the statute. It's a statute which is followed in Nagaland. This is rules for administration of, what is this statute called? Rules for Administrative Justice and Police in Nagaland 1937.
Yes, 1937.
So under this is not maintainable. Yes, tell me what is to be done, because I don't have power. You have committed, it seems you have not gone through this properly. You withdraw it, I think you withdraw it.
Lordship.
and You withdraw it with the liberty to approach the Deputy Commissioner. That will be the best.
Appropriate authority.
You withdraw this. I'll pass the order. I'll pass a little bit detailed order. I mean, only the telling about the facts and all. Or I need not, probably. I need not.
No, Your Lordship, since they are withdrawing it, we did not need to go to the facts, Your Lordship. Since if they are withdrawing it,
I need not.
no, Your Lordship.
Mr. So-and-so, what is your name?
Abel, I am a Lordship.
Learned Counsel appearing for the petitioner. Heard Mr. So-and-so, also heard Mr. Angami, the learned senior government advocate for the respondent.
1, 2, and 3, Madam.
This is a revision petition under Article 227 of the Constitution of India, read with Rule 32. Read with Rule 32 of Rules for Administration of Justice and Police in Nagaland, in bracket, Third Amendment 1984, bracket complete, and Section 115 of Code of Civil Procedure 1908, impugning the order dated 19/8/2025 passed by Sub-Divisional Officer Civil in appeal case number 1/2025 arising out of land dispute case number 115/2025 dated 19/9/2024. While the matter was being heard, the learned senior government advocate appearing for the state respondent respondent submitted that this revision petition, that instant revision petition, is not maintainable in view of the fact that there is a statutory alternate remedy by way of appeal before the Deputy Commissioner under Rule 29(1) of that Nagaland. This court has perused that. This court has perused the particular rule, that is 29 in bracket 1, which clearly reveals that there is an appellate provision available for the petitioner.
Lordship, there is a delay in approaching the appropriate authority. So if this honorable court may
So you
kindly...
should have filed 30 days.
Yes, Lordship.
Should I? I'll give this guy, because he has approached this court. Let him try the.
Yes, at least that liberty.
Let him.
At least that liberty. That may be granted.
That's why I wanted to put it little bit so and so. However, it is seen the time period for appeal before the district commissioner has already been elapsed. After considering the factual matrix of the case and that the petitioner has approached this court by filing the instant petition, this court is of the view that liberty should be granted to the petitioner to approach the deputy commissioner by filing an appeal. Therefore, it is directed that the limitation of 30 days as prescribed under 29(1) should be exempted should be exempted. And the petitioner shall submit his, the petitioner shall file his appeal before the DC within 30 days from passing of this order. In view of the, I'll record here this thing that you are not objecting to this?
Lordship,
You are
no.
not objecting to this?
No, Your Lordship.
In view of the aforesaid direction, this instant revision petition is dismissed as withdrawn. Okay? So you have got the liberty at least 30 days. 30 days time you are getting it. Because of your effort and whatever the dispute is, there is a village dispute.
Yes.
So considering all those things,
Yes.
that liberty has been
Yes,
given.
yes.
Thank you. Oblige, Your Lordship.
I am deeply obliged.
For admission, item number 3.
Yes.
Lordship, I prefer this civil revision. If the opposite party is not filing the affidavit, it may be listed for hearing.
It hasn't filed, they haven't filed it. What happened?
Lordship, this is revision petition.
Sorry?
This is revision petition, Lordship. This is a revision petition.
So you are contesting the matter? You are
Yes,
appealing?
I'm contesting for the respondent, sole respondent.
Where is the brief?
Oh, Lordship, we are not filing any counter on this because this is a revision and records have been called for.
So you are ready with the matter to argue this today?
If they are ready. Because
They-
revision is yet to be admitted.
Your Lordship, motion has been moved on 7/8/2025. And then after a lengthy hearing, notice has been issued
It has
to the
come. It has come
respondent.
on the admission section only.
Yes, Your Lordship.
Correct.
Even stay has been granted on the
By
subsequent
order,
date.
expenses will call for the calculator has been received without index space and position registry. So you can attempt format and index the base of the leave. Required with the assistance of Yes, record has come. They are not filing any affidavit. So are you ready with ready for argue the case? That's what I'm
Your
asking.
Lordship, I'm not ready today. If a short date
That's
may be
what I
fixed.
was asking.
Yes, Lordship.
MS so-and-so, learned counsel appearing for the petitioner, submits that she is not ready to argue the matter today. Therefore, prays for a short accommodation. Prayer is allowed, let this matter be listed after a week.
Lordship. Obliged, Lordship.
Mr. MS so-and-so appears for, write her name also.
For admission, item number 5.
Yes.
Please, my Lord. Lordship, the Department is engaging on special counsel from outside. So if the matter may be listed next week, Lordship.
Lordship, in that case, in the
You are Mr. K.V. Angami?
Yes, yes, Lordship. Yes.
The learned PP, Mr. K.V. Angami, the learned PP appearing for the respondent, submits that that a special counsel will be engaged to argue the matters on behalf of the respondent state.
Lordship.
This is respondent? Who is the respondent?
Sole respondent, Lordship.
Respondent state. In view of the aforesaid, he prays for a short accommodation so that the special counsel could be engaged and he can appear before this, appear on behalf of the state. Mr. Moa,
Jamir, Lordship.
Mr. Moa Jamir appears for the petitioner.
Your Lordship.
Appears
Lordship, I have a
for the petitioner. Yes.
small prayer, Lordship. If in the meantime, if I may be allowed to file an affidavit enclosing the charge sheet, because while pending this criminal
Charge sheet has been
petition,
filed?
yes, Lordship, charge sheet has been filed, Lordship.
Mr. Moaz Jamir appears for the
Petitioner.
petitioner
Petitioners.
and submits that in the meantime, charge sheet has been filed in the instant case, and in view of that, he prays that he should be allowed to file an additional affidavit
Lordship.
to bring on record the aforesaid charge sheet. Prayer is allowed.
If the matter may be listed after 3 weeks,
Prayer
Lordship.
is allowed. Let the matter be fixed.
Lordship, if maybe listen next week so that the newly engaged special counsel may get familiar with the case. In the meantime, he can keep on filing sick time
He
again.
can go through the brief, Lordship. If I may be allowed 3 weeks' time, Lordship, to place a
You can
recording.
appear after 3 weeks also. What
Lordship.
is there? You can always file in Wakalatnama, and special counsel can file in Wakalatnama if it is required at all, because he will be appearing as a special counsel for the state. He will need a Wakalatnama probably. So let the matter be fixed after 3 weeks. In the meantime, the learned counsel for the petitioner shall file the additional affidavit.
Lordship.
Much obliged. For admission, item numbers 6 and 7.
May I please, Your Lordship?
Yes.
Lordship, this is an application for condonation of delay for restoration of the main appeal. However, the Honorable Court, by the last order dated,
Item number 6.
Lordship. Item number 6, Lordship.
So paper publication was supposed to be done.
Yes, I have made the paper publication, and it is also.
Have you filed an affidavit?
Yes, Your Lordship. It is already on record, Lordship.
So you have filed an affidavit of paper publication.
Lordship. Upon respondent number 3, Lordship, the owner of the vehicle, Lordship.
Yes, paper publication is done.
Yes, Lordship.
You are appearing for whom?
I am appearing for respondent 1 and 2.
Respondent number 1 and 2.
Yes, claimants.
So in the application for condonation of delay, no notice was served, or no notice was issued, or notice was issued, and that is about paper publication.
Yes, yes, Lordship. Notice was issued, Lordship.
Okay. So now this is the service is complete now.
Service is complete upon all.
The service is deemed complete, and you have any objection to the?
Yes, I have filed my.
You have filed your affidavit.
I have filed affidavit. If Your Lordship may go through the IA.
Yes.
There is no explanation for the delay.
Lordship, it is explained in paragraph 5, Lordship.
This is the one. This is the one.
So you are appearing for respondent number
1 and 2.
1 and 2.
Yes, the claimants.
The Bharati Kumar and
Yes. Even in the main dismissed petition, they have approached this court after almost 2 years. And then for prosecution, it was dismissed for default. Now they have again filed for.
dismissed for default.
It was dismissed for default, and then after more than 107 days of delay, they have again approached.
But
for
they are saying
restoration.
107 days delay.
Lordship, in filing the restoration, Lordship. In filing the restoration petition, Lordship, there is a delay of 107.
Have you filed a restoration petition? Restoration petition where? You have filed before the MSC?
No, Lordship, before this honorable court, Lordship.
Yes.
No,
The IA 90. IA 90. Yes.
IA 90, Lordship. Actually, it should have been, the 90 would have been this delay condonation, and 91 would have been the restoration. It is
90.
No, not 90. Where's the other one? 92.
No, there is only one IA I am finding here.
Lordship, there are two IA, Lordship. IA 90 is the restoration and IA 91 is the delay condonation.
91, yes. IA 91 is the
Delay condonation. And 90 is the restoration.
Yes.
So let us first see like what is there in the number this thing 90.
Lordship.
Once it is restored, then only delay could be considered.
Lordship.
Correct?
Yes, Your Lordship.
Lordship, at para 5, Lordship. Internal page number 5 at para 5, Lordship. If I may read, Lordship.
No, I am reading it.
Lordship.
Your Lordship, I'm sorry, that the condonation should be considered first?
Yes.
Yes, only after that restoration issue will come.
But is there any limitation for, restoring the matter?
Your Lordship, an application, Your Lordship, Section 5 of the Limitation Act, it says any appeal or any application other than an application under any of the provisions of Order 21 of the Code of Civil Procedure.
Is there any limitation for restoration?
Your
The
Lordship,
Limitation Act.
there is no under.
Yes, Mr. Counsel, is there? Why have you filed this thing IA for condonation of delay?
Lordship, the Limitation Act says that 30 days from the date of dismissal.
Where is there, which provision?
Lordship, Section 5 of the Limitation Act, Lordship.
Dismissal from what? I mean, dismissal for default.
No, not, it is not specifically mentioned for
No,
dismissal
what,
for default.
then from which order? 30 days from which
Lordship,
order?
from the date when it was dismissed, Lordship. Actually, Lordship, if your Lordship may kindly peruse the last order dated 28/1/2025, Lordship.
Passed in?
Passed in, Lordship, the main IA 210.
Huh?
210, Lordship.
210.
Lordship, it is not it is not, I think, tagged with this particular IA 91 because it is with the main appeal, Lordship. IA 210 was the delay condonation petition filed in the main appeal, Lordship, and I was advised by this honorable court to file an additional affidavit, and I have already filed, and it was placed on record.
See, let me understand the thing. First thing is that you have filed an appeal, correct?
Lordship.
Then your appeal got dismissed because of non-appearance,
Lordship.
right?
Lordship.
Then you want to restore this, so you have filed an IA for restoration.
Lordship.
And along with the IA, you have filed a petition for condonation of delay. Application for delay. Delay for what?
Delay in filing the restoration petition, Lordship.
Is there any provision in the Limitation Act that if the matter is dismissed for default, for non-appearance, then you'll have to file a delay condonation application?
No such provisions.
Then how you have filed this?
No such provisions.
So here this has been recorded, the prescribed limitation in filing restoration petition 30 days.
Lordship.
So where is that provision? That's what I wanted to know.
Lordship, actually there is no such provision that guides for dismissal for default. There has to be one IA, for delay condonation.
Oh, yes.
Is there?
Your Lordship.
Yes, show me that.
The Limitation Act, if your Lordship may go through page 126 for page 31.
Yes, page 31.
Yes, the period of this is
page 31.
This is part 2 suits relating to. Sorry.
No, which
page 31. There is under 122 description of application. 122. Whether the page is same or not.
Serial number 122.
122.
122. Okay.
Yes.
Yeah, restore a suit. Yes,
or appeal or application for review,
applications
revision,
in
dismissal, or default, or of
specified cases.
or for one or
To restore a suit or appeal or application for review or revision. Dismissed for default, for appearance, or for want of prosecution, or for failure to pay costs, 30 days. So it is there, 30 days.
Yes.
Mr. Counsel, you have filed the application and you are saying there is no provision. What is this IA 92 again?
This for the stay of. different one. Huh?
See, only explanation they have given is the date. It was not noticed by them in the cause list, and because of that,
Yes.
this has
But
been.
then, yes.
So that's why the delay has occurred, and it should be condoned.
But then there is 107 days of delay, Your Lordship.
Because
so
it
they
was-
have to explain it.
No.
Yes, within 30 days they ought to have known, and then at least they ought to have said that this thing occurred after
No,
the 30
the
days.
only explanation is that they did not notice it.
Your Lordship, it is the duty of the council to pursue the matter.
Lordship, that is the duty of the council, and after 28/1/2025, this case has not been listed, Lordship. And it is only after I have pursued the matter with the registry, Lordship, I have come to know that this was dismissed for default. Then I have applied for the certified copy and I have just filed this petition, Lordship. And thereby the delay occurred, Lordship. And Lordship,
Correct. That is, but only thing is that you are saying is that there is a default on your part.
Lordship.
Part that the matter was not. I mean, somehow it was missed out.
Lordship, due to an oversight, Lordship, it has been missed out, and I really apologize for my mistake, Lordship. I really apologize for that, Lordship.
Course lists are published.
But what is to be done? Yeah, that the learned counsel is. I mean, saying that he somehow overlooked it and he missed out, and delay had occurred for that, because it's not a kind of a regular. Where a regular petition wherein a continuation of delay has been sought for, because he was aware of something, and in spite of that there was some delay. But here he was not aware of this thing, so he's asking for continuation because of that.
Your Lordship.
So now it's up. I mean, what is your submission on that?
My only submission.
Your
is,
submission is that because
yes.
There was no proper explanation.
Yes, proper
The proper explanation he could not do now because he was not aware of this. That is his submission.
But then it is through his negligence, Your Lordship.
Correct. So now
through his negligence.
Now, whether
I'm admitting it, Lordship. I'm admitting. I'm
lists are published.
now for that, whether
Yes.
the council, whether the client should be suffered for this. Otherwise, the client will suffer. That aspect has to be also looked into, because
Your Lordship, I'll leave it to Your Lordship. But I'm just saying that in cases of such delay, at least reasonable explanation as to the daily, within the interim period of 107 days, that is how many months it is, Your Lordship. Even in the main appeal, which was dismissed, there also they have filed an application for continuation of delay of more than almost 3 years. In that case also, that was how much they have neglected. Then they have approached this court only after this execution proceedings were initiated. Then in the meantime again, for negligence, they have the matter was dismissed for default, and now after more than 107 days of delay without explaining the delay, their only excuse is, I did not know, the council did not. There was oversight on the part of the council. At least this is very casual, Your Lordship. This is a casual.
No, I understand,
Yes,
but
it is
he's
a very-
admitting his fault. He's admitting
Yes.
his fault. He's admitting his fault.
Yes.
And on oath, he's saying that there was some overlooking on his part.
I'll leave it to Your Lordship's wisdom. The only thing is that I'm objecting.
Yes. you write in IA number 91. This is an application. Yes, this is an application under Section 5 of Limitation Act 1963, praying for condonation of delay of 107 days in filing the filing the IA, that is IA number 90 of 2024 for restoration.
Lordship, 90 of 2025, Lordship.
Yes, 90 of 2025 for restoration of don't write restoration, for praying for recall the dismissal order dated 28/1/2025 and to restore the MSc appeal number 8 of 2024 for hearing. Mr. Bikramjit Devnath, appearing for the applicant, submits that the dismissal of the appeal, dismissal of the connected appeal on 28/1/2025 was result of an unintentional oversight on the part of the applicant's counsel, who failed to notice the listing of the matter in the cause list on the particular date. Particular date. He submits that it was only upon subsequent reviewing of the case status online that the applicant's counsel came to know about the dismissal of the connected MSc appeal. Thereafter, the learned counsel, or thereafter the counsel appearing for the applicant applied for the certified copy of the dismissal order dated 28/1/2025 and The instant application was filed finally on 18/6/2025, thereby causing a delay of 107 days in filing the IA. Next para. Notice was issued in the instant IA and the opposite party numbers 1 and 2.
Yes.
1 and 2. Opposite parties number 1 and 2 have already filed their objection to the IA for condemnation, IA for praying for condemnation of delay. The council, Mr. So-and-so of the Ladder Council, appearing on behalf of the opposite parties number 1 and 2, has submitted that there is no explanation of delay of 107 days in the IA that has been filed by the applicant. Therefore, he prays that the delay should not be condoned. After looking into the matter in entirety and taking into the fact that there is an admission on the part of the council appearing for the applicant that it was due to his oversight, his unintentional oversight, that he could not be appeared in the court on the particular date when the appeal was dismissed for non-appearance. This court is of the view that the instant application merits interference of this court, and therefore this instant IA, therefore this court allows the prayer for condonation of delay of 107 days, and accordingly the instant application is disposed of as allowed. This is in 91, right?
Your Lordship.
Then in 92, in 90.
90, Your Lordship, restoration.
Heard the council, heard Mr. So-and-so Devnath, and Mr. Devnath appearing for the applicant, as well as Mr. So-and-so appearing for the opposite parties number 1 and 2. Who is respondent number 3?
He has not filed his wakalat nama as yet. Respondent number 3 is the owner of the vehicle, Lordship.
So paper obligation has been done on.
Yes, Your Lordship.
In that IA, the earlier IA, you write that as far as respondent number 3 is, you write from the records it is found that as far as notice upon respondent or a notice upon opposite party number 3 is concerned, a paper publication has already been done by the council for the applicant, and by the applicant, now don't write council, by the applicant, and the same, and an affidavit to that effect has already been filed. In view of the aforesaid, the service upon respondent number, opposite party number 3 is deemed to have been completed. So in heart so and so, this is an application under order 41, rule 19 of CPC, read with section 151 of the 151 of CPC, praying for recall of the dismissal order dated 28/1/2025 and to restore the MSc appeal number 80/2024 for hearing, which was dismissed vide an order dated 28/1/2025 for default non-prosecution. Default stroke non-prosecution. There is a delay of 107 days in filing the instant application, instant IA. Therefore, IA number 91/2025, praying for condonation of the delay of filing the instant IA has been filed, and on consideration this court has allowed the IA for condonation of delay. Full stop. Next para. The learned counsel appearing for the applicant submits that the order dated 28/1/2025, by which this court has dismissed the appeal for non-appearance of the counsel, was in fact due to an unintentional oversight on the part of the on his part, and because of on his part, full stop. The learned counsel submits that once he came to know about such dismissal, while looking into the online status of the appeal, he immediately procured the certified copy and did the needful for filing the instant IA for recalling of the aforesaid order of dismissal and restoration of the appeal. Therefore, he submits that this court, for interest of justice, allow this instant application and restore the connected appeal so that the matter can be heard on merit. The learned Mr. So-and-so, learned counsel appearing for the opposite parties number 1, 2, however, objects to such restoration. You are objecting to it?
Your Lordship, I have no objection.
Mr.
I have
So-and-so
no objection.
does not object to such restoration of the appeal. After hearing the parties, this court is of the opinion that the application merits, that the instant IA merits to be allowed, and thereby recalling the order date or recalling the aforesaid order dated so and so, and restore the connected MSC appeal number so and so for further hearing. Accordingly, the instant application number 90 of 2025 is disposed of as allowed. The earlier application is also disposed of, okay? And what is the 92?
Okay, 92 is the stay for the execution proceedings in the learned, before the learned tribunal also. Stay of the execution proceedings.
What is your
Execution proceeding, your lordship.
Lordship,
It is going on.
So that will stay because this is a this application has been filed by the applicant for staying of the further proceedings in the execution case number 2024. Case number 2 pending before
the learned MACT Mokchung, Lordship.
pending before the learned MSc Mokokchang. In view of the order passed by this court, recalling the order dated so and so, passed in what is the MSc appeal number? Passed in MSc
8 of 2024.
2024, and restoring the same for further hearing. This court is of the view that the further proceedings in the execution case number 2 of 2024 may be stayed till disposal of the connected MSc appeal. In view of the aforesaid direction, this instant IA is disposed of as allowed. Let the so once it is restored, then only appeal will be
Yes, the main appeal. In
the main appeal has to be listed.
Yes. Is it this?
It's not yet here.
It's not here. But there has to be one direction, no? That main appeal has to be listed.
Yes.
In the IA for restoration.
Yes, your lordship.
In the IA for restoration, you write, the main MSc appeal is directed to be listed after 3 weeks.
Your lordship.
After 3 weeks.
Lordship.
For admission, item number.
So these 3 IAs are disposed of.
Your lordship.
And the MSc will be restored and it will be listed after 3 weeks.
Your lordship.
Lordship. I'm obliged, Lordship. Keep you.
May it please, Your Lordship. Lordship, I have instructions to appear for the performer respondent number 1, but I'm yet to file my vakalat naman. So if I may be granted some time to file my power as well as a short affidavit.
I mean, where are there 2 IAs and then you are appearing in which matter?
In the appeal, my lord.
So in non-notice has been served in this thing. MS so-and-so, learned counsel appearing for
Lordship, I am for respondent number 1 to 7.
appearing for respondent number?
The performer respondent number 1, my lord.
Performer respondent number 1 and submits that she is yet to file a wakalatnama, though she have instructions to appear in the matter. In view of the aforesaid, she submits that the matter may be listed after 2 weeks so that she can file the wakalatnama.
Lordship, I am appearing for respondent number 1.
One second. I am passing some order. Don't you have some patience? Can't you hear it that a court is passing some order?
Sorry, Lordship.
What is your name?
Sharif Ahmed, Lordship.
What?
Sharif Ahmed.
Mr. So-and-so appears on behalf of
Respondent number 1 to 7.
Respondent number 1 to 7. Let this matter be listed after 3 weeks.
For orders, item number 9.
May I please, Your Lordship? Lordship, here in the contempt petition, Your Lordship, the respondent 5 and 8 is no longer holding the post, so I may be granted 1 week to file an IA.
Learned Counsel, you are Mr.
Sopongwati.
Mr. Sopongwati Waling.
Lordship.
Sopongwati Waling, appearing for the petitioner, submits that the respondent number, I mean, you have already given some time.
Yes, Lordship, but then I was also informed that the respondent number 8 also been replaced, Lordship.
No, I mean, now you are talking about whom? You were seeking time to...
For 5 and 8.
5 and 8.
Lordship.
Okay. But you are yet to, okay. 5 for 5, you have not filed anything till now.
Not yet, Lordship.
Mr. So-and-so appearing for the petitioner submits that respondent number 5 and respondent number 5 as 8 have been transferred from their respective posts and new incumbents have joined the respective post. Accordingly, he seeks 2 weeks time?
Lordship.
2 weeks time to file an IA for implement of the new incumbents. New incumbents for respondent number 5 and 8. Mr. You are appearing?
For respondent 9 and 10, Lordship.
So appearing for
on behalf of additional AG in Tim Song.
So-and-so appears for so-and-so. Prayer is allowed. Let the matter be fixed after 2 weeks.
Much obliged.
For orders, item number 11.
Yes.
Lordship, on the last occasion, this Honorable Court had directed the concerned police station, the OC, to file a report.
Yes. You are appearing for whom?
For Vijimomi, Lordship. He's in this post, Lordship, so...
But this,
I was told that he has not received the record yet, Lordship. So if 2 weeks' time may be granted to me.
We'll post it for after a week because Zimomi is not there.
Yes,
let him be there. Let him be there so that, I mean, if there is something, so he can give the updated status.
Lordship, will that require a week? Because today is the
Because
date when
Zimomi is not there today.
Yes.
I mean, she is appearing on behalf of Zimomi.
Yes, Lordship.
Yes.
But I don't know why Zimomi is not appearing. He should have been here.
Lordship,
and-
yes, a
He's in this
judicial
post,
order has
Lordship.
been
He's in
duly
this
passed.
post. He's in this post, Lordship.
Lordship, yes, but at least whether a report has been filed could have been
Yeah,
placed
that is
before
what I mean.
this
I mean,
court.
otherwise the
Lordship,
matter is
yes.
pending. I mean, at least you tell me, Mr. Jibomi, that if there is no report, from the police, then what this court can do? This court can appoint some amicus to appear on behalf of this. So because only for the report this court is waiting. If there is a service on the respondent number 2, then that respondent number 2 may like to appoint his or her own counsel.
Yes, sir.
But in spite of notice, if she is not coming forward and appearing before this court, then because this case is relating to POXO offense, so the court will appoint somebody as an amicus to assist this court and appear on behalf of respondent number 2. It's like on a joint prayer. I'll put it like that. Now on the prayer of respondent number, on the prayer of MS so-and-so, appearing on behalf of Mr.
Vijimomi, Lordship.
Vijimomi.
Lordship.
He is the APP.
He's the PP, Lordship.
Vijimomi, the APP. Let the matter be fixed after a week. This court, the Mr.
Alizo A. Kire, Lordship.
Mr. So-and-so, appearing on behalf of the petitioner, has submitted that though the matter has been listed before this court,
Report of IO.
for more than
report of OC, I'm sorry. report of the concerned police station.
The matter is listed for how many times?
This is the third occasion, my lord.
The matter has been listed more than a couple of times. This court is the learned PP is yet to intimate the court whether the service upon respondent number 2 through the concerned OC
Yes,
of the concerned OC of the police station has been received or not. Has been received or not.
Yes, whether the OC was able to find
That's
the
what
whereabouts of the victim.
Any report from the OC,
Lordship, yes.
received or not. In view of the opposite, he submits that the learned PP should be directed to submit before this court on the next date of submission about the updated status of service of notice on respondent number 2. Full stop. After considering the submission, this court is of the opinion that the learned PP should take the efforts to contact the concerned OC to find out whether the service upon respondent number 2 is completed or not. After taking the instructions from the concerned OC, the learned PP shall intimate this court on the next date of hearing about the updated status of service of notice on respondent number 2. Let this matter be fixed after 2 weeks.
A week's time, Lordship? A week's time,
After
the
2 weeks,
concerned police station is here only.
After 2 weeks, let him take the instructions. I have directed that he should take instructions whether it is sufficient or not.
Very well.
The next date you will get to know whether it is served or not. If it is not served, then amicus will be appointed.
Very well, ma'am.
It will be after 2 weeks.
Lordship.
So you please tell Mr.
Lordship,
Jimomi that he should give the updated status. Okay?
Lordship.
Otherwise, there is no problem. We can engage somebody from the amicus list.
All right. Objection.
For others, item number 12.
Yes.
Lordship, this is a contempt petition, Lordship.
Yes. Implement has been done, all implements.
No, Lordship, as far as
you were supposed to
respondent
file
number
an
2 is
impl-
concerned.
Huh?
Yes, Lordship, I'm yet to file the IA for implement, Lordship.
Mr. So-and-so, Mr. Moa Imchen, learned counsel appearing for... You are Moa Imchen?
Jamir, Lordship, Moa Jamir, Lordship.
Moa Jamir.
Lordship.
Sorry, I got confused.
Yes, Lordship, I understand, Lordship.
Mr. Moa Jamir, the learned counsel appearing for the petitioner, submits that he needs 2 weeks time for filing an IA for implement of whom?
Home Commissioner as respondent number 5, Lordship.
Impleading the new incumbent.
Yes, Lordship.
For respondent number?
5, Lordship.
5. Respondent number 5. The prayer is allowed, let the matter be fixed after 2 weeks.
Lordship, in the meantime, the other respondents may file their respective affidavits, Lordship.
They should file. Write their names. Mr.
number 2. I am yet to file my...
I will be
allowed to file my...
Mr. So-and-so, your name?
Moa Imchen.
Moa Imchen. You are Moa Imchen and he is Moa Jamir.
Lordship.
Mr. Moa Imchen, appearing for respondent number? 2. Respondent number 2 submits that he is yet to file the wakalatnama. So, in the meantime, in coming 2 weeks, he will file the wakalatnama. He will file the wakalatnama and he will file the counter?
I will file the wakalatnama
I'm allowing 2 weeks time to you. So in the meantime, you file the counter.
Contempt petition, Lordship, they should expedite.
And it's like write that he will file. In the meantime, he will file this wakalatnama. And we are appearing for
Respondent number 3, Your Lordship.
MS so and so appears for respondent number 3. You are appearing
For 1.
Yes. Mr. Angami appears for respondent number 1. Let the matter be fixed after 2 weeks.
Obliged, Lordship.
For others, item number 15.
Lordship, similar order may be passed because the new incumbent Home Commissioner, Lordship, I have to implement the new
Is
incumbent.
same respondent?
Yes, Lordship, same respondent.
And all the parties are same. I mean, all of you are appearing for the respective parties, eh?
No, Your Lordship, I am for respondent number 3.
Here you write same order, no? Talam? Same order earlier. Only thing is that Mr. Moa Imsen is appearing for respondent number 2 and 3. And you have not filed the Wakalatnama.
Wakalatnama, newly implemented, I have to file.
Huh?
For newly implemented respondent, I have to file.
Okay, but otherwise you have filed.
Yes. Other one I have filed. Contained respondent number 3, I have filed.
That like once he is impleted only then only you
Yes,
file.
Lordship, yes.
So Mr. So-and-so appears for respondent number 2 and 3.
Yes.
2 and 3 and Mr. You are appearing?
Yes.
Respondent number 1.
One.
So-and-so appears for, let the matter be fixed after 2 weeks.
Lordship. Much obliged, Lordship.
For others, from the supplementary cost list, item number 24.
Yes.
Lordship, this instant IA is filed for withdrawal of statutory fee, which has been statutory fee. Statutory fee.
You want to withdraw this?
Yes, Your Lordship.
Why?
Because the case has been dismissed by court order dated 18/9/2025.
18/9?
18/9/2025, annexure A.
So IA is dismissed.
Yes, it was not condoned. My condonation was
Then
not
why
condoned.
this, no order was passed in this?
The order was passed, Your Lord.
No, I mean, in this main appeal?
Make appeal, yeah.
No, this is IA for what? 95.
For withdrawal of 25,000 statutory fee. Which was given during.
25,000 statutory fees?
Yes, which was given during the time of filing.
Heard MS so-and-so, learned counsel appearing for the applicant. This is an application for withdrawal of statutory fee of rupees 25,000. Only in IA number 54 of 2025, in MSC appeal number 5 of 2025, which was dismissed by order dated 18/9/2025. In view of the aforesaid dismissal, the instant IA has been filed for withdrawal of the statutory fee of rupees 25,000, which was submitted by the appellant while filing the MSC appeal number 5 of 2025. The prayer is allowed. Prayer is allowed, and the applicant is allowed to withdraw the statutory fee of rupees 25,000, aforesaid rupees of 25,000, filed while filing the MSC appeal number 5 of 2025. In view of the aforesaid direction, this instant IA is disposed of.
Oblige Your Lordship.
As allowed.
For others, item number 25.
You are appearing 25?
Yes, Your Lordship. This IA is for amendment of the cost title, Your Lordship.
IA is for?
Amendment of the cost title in MSC number 18 of 2025, Your Lordship.
IA number 196.
18. IA number, yes, 196.
Heard MS so-and-so. This is an application. This instant IA has been filed paying for amendment of the cost title in MSC appeal number 18/02/025. Amendment for what?
Cost title, Your Lordship.
Cost title, because what was the mistake?
I have mentioned the judgment dated as 28/2/2025 instead of 22.
Judgment dated, okay. The learned counsel appearing for the applicant submits that there was a typographical error, typographical error to the effect that the date of judgment should have been 28/2/2025 instead of 22/4/2025 in the cause title. And also instead of MSc case number 16 of 2024, now instead of MSc case number 212 of 2026, instead of MSc case number 16 of 2024, correct?
Instead of 16/2024, we have entered 212 of 2016, Your Lordship.
What happened? Instead of? No. Instead of MSc case number 16 of 2025-24, mistakenly, MSc case number 212 of 206 has been written. In view of the aforesaid inadvertent errors, the learned counsel appearing for the applicant praise for allowing those mistakes to be corrected by way of filing this instant application. Instant application is allowed. The counsel for the applicant is allowed to correct the aforesaid mistakes by submitting a new cause title. By submitting a new cause title within a period of 2 weeks. 2 weeks. In view of the aforesaid direction, this instant application instant IA is disposed of.
Much obliged, Your Lordship.
For hearing, item number 26.
Today, I don't think it will be possible to hear this matter because there are a series of matters fixed at 2 o'clock.
That is what we have been discussing also, Lordship.
Yes.
I leave it to your
So
Lordship.
some other day?
Yes,
Lordship, if it may be fixed on 6th.
Due to paucity of time, this case could not be heard today and heard today full stop. On agreement of the learned counsels appearing for both the parties, for the parties, right? Not both, for the parties. Let the matter be fixed on
6th of November.
6th of November.
As fixed item, Lordship.
Lordship, if I may, I'm for the state respondents. On 6th, I have some personal difficulty, Your Lordship.
Huh?
On the 6th, I have some personal difficulty.
Yes, some other day agreement.
13?
Huh?
No problem.
13? 13th.
So,
13th, I have some difficulty, Lordship.
Okay.
Can we try on Thursday? This Thursday?
Lordship, I'll be on leave.
So he come to an
Lordship,
agreement.
after 2 weeks, Lordship.
Huh?
It will come after 2 weeks.
Then somebody may not be there also. You come to an agreement,
Yes.
Mr.
From
Jamil?
12 to 14,
You are
I'll
not
be
there.
outstation. Yes.
Before 12, some other day?
11, bro.
Yes.
11th.
Okay.
11th. Let the matter be fixed on 11th of November.
11th, I hope it is not on Wednesday.
Tuesday.
Yes.
Tuesday.
That will suit us.
That will
Obliged,
be-
Lordship.
Yes. Yes.
for admission, item number 20.
Item number?
20.
Excuse me.
Motion.
For motion, item number 19.
My lord,
Yes.
there is few problems here. I have sent an instruction to my client, who is already in the custody. So they are seeking one day, do not communicate this to. He is already in custody. So he is just saying that one more day, like it can be fixed on Thursday. If you see that we have to withdraw, we'll withdraw it on Thursday. But subject to condition that their instruction has to be given from my client. As I have sent this charge sheet to them also, only Thursday in the morning.
Thursday in the morning?
Yeah. Unnecessary also we don't want. They want, doesn't want.
On the prayer of Mr. D. Das, the learned senior counsel, appearing for the petitioner, let this matter be fixed on, it will be on
Thursday.
on Thursday, that is?
30, Lordship.
That is 30th of November, in motion column.
Sorry for troubling.
That is fine.
My lord, your lordship will just take item number 21, which your lordship's hearing yesterday. 20 we have completed, only 21, item number 21. 2-3 judgments is to be shown, then I am done, my lord.
Yes.
So my lord will order to Sabha, order to Kohima middle order. I'll just before that,
Yes.
your lordship will kindly see the judgment, page 14 of the paper book, compilation of the judgment, page 14, which is item number 21, which is already there in the petition, but in a compilation I have given. Your lordship has seen that compilation also yesterday.
Order copy has been.
Yes, right.
That compilation.
Please see page 15, my lord.
Page 15.
Yes, which order is 7/4/2025.
Yes.
Passed in IA number criminal 4 of 2025. Because in this case, as it was an appeal, my lord, we filed an IA for stay.
Yes.
That's why in an appeal, separate application has to be filed. That's why.
So
Now,
that is.
yes. Now, my lord will kindly see paragraph 2, my lord. The interlocutory application, paragraph 2.
Yes.
The IA has been filed by the applicant C. Bhupesh Arora in connection with criminal appeal number 1 of 2025, praying for stay of the operation of the impugned order dated 22/1/2025 and subsequent consequential order passed in the court of the learned principal session judge cum special judge PMLA Dimapur, Nagaland, IA number 791 of 2024. That 791 declaring as a fugitive economic offender filed by the ED. arising out of ML case number 1 of 2024. That's a complaint case pending before the Court of Learned Special Judge, Dimapur, whereby the applicant has been declared as a fugitive economic offender within the meaning of section 21F of the Fugitive Economic Act 2018. The facts relevant for the consideration of the instant IA in brief are that 1. In person, the complaint under section 44 and 45 of the Prevention of Money Laundering Act and the investigation which ensured thereafter, charge sheet was laid down against the present applicant and 298 other accused persons under section 4 of PMLA before the Court of Learned Special Judge PMLA, Dimapur, Nagaland. The said case was registered as money laundering case number 1 of 2024. On 22/3/2024, Learned Special Judge PMLA, Nagaland took cognizance of the offence of money laundering case all 299 accused persons including the applicant and thereafter issued summons to them. Upon receipt of summons, the applicant on 24/5/2024 entered his appearance to his engaged counsel. Though the applicant was allowed to be represented by his engaged counsel in the said case, however, on 2/7/2024, which was an off date, the trial court heard an application filed by ED for issuance of non-bailable warrant, which was registered as IA number 230 of 2024, and without hearing the counsel of the present applicant, issued non-bailable warrant of arrest against him. On 29/8/2024, the applicant filed an application challenging the issuance of non-bailable warrant of arrest against him, which was registered as IA number 531 of 2024. The ED prayed for filing an objection against the said application, and on the prayer of the learned counsel for the applicant, the court preponed the date of hearing of the said application to 5/9/2024. On 5/9/2024, trial court heard the learned counsel for both the sides in connection with IA number 531 of 2024 and directed that IA number 230 of 2024, in which non-bailable warrant of arrest was issued, is required to be reheard, and accordingly the trial court directed that a non-bailable warrant of arrest already issued against the applicant shall be kept in abeyance till next returnable date, that is 18/10/2024. The IA number 531 of 2024 was accordingly disposed of. On 18/10/2024, matter could not be heard as a copy of the application in IA number 230 of 2024 was not furnished to the applicant. Therefore, the next date was fixed on 12/12/2024, and the interim order passed in IA number 531 of 2024 on 5/9/2024 was directed to be continued till the next date. However, on 24/10/2024, ED filed an interlocutory application which was registered as IA number 791 of 2024, wherein it prayed for declaration that the applicant to be a fugitive economic offender under Fugitive Economic Offender Act 2018. Thereafter, by order dated 22/1/2025, trial court allowed the IA number 791/2024 and declared the present applicant as a fugitive economic offender. Applicant has impugned the aforesaid order dated 22/1/2025 by filing an appeal under section 17 of the Fugitive Economic Offender Act 2018, which was registered as criminal appeal number 1 of 2025. Said appeal is admitted for hearing. Next date is fixed on 28/4/2025. In this IA, applicant has paid for stay of the impugned order dated 22/1/2025 during the pendency of the aforesaid appeal. Now, this is what the factual part has been stated. Now, what is the submission? Mr. So-and-so learned senior petitioner has submitted. Trial court, by declaring the applicant as a fugitive economic offender, has failed to take into consideration that though an off date, that is on 2/7/2024, the trial court has issued non-bailable warrant of arrest against the present applicant. However, it has been submitted by learned senior counsel for the petition that said non-bailable warrant of arrest was kept in abeyance by an order dated 5/9/2024, passed in IA number 531 of 2024, and therefore no effective non-bailable warrant of arrest was pending against the present petitioner on 24/10/2024. That's what I argued yesterday, my lord. There was, because as it was kept in abeyance, so there could not be any application filed by them, that this become, the application was on that particular day, my lord, could not have been filed. The
Can you
ED has.
review, and like after consideration of all this, your petition was allowed, IA was allowed?
Yes.
Yes.
The ED has filed the application declaring the present applicant as fugitive economic offender. Learned Senior Counsel has also submitted. Trial court has again issued non-bailable warrant of arrest against the applicant by its order dated 13/12/2000.
No, that I have gone through.
Your
So
Lordship has
that's-
gone it.
Yes,
Now,
yes.
my Lord will kindly see what is the argument of the ED at page 20.
Page 20, yes.
Page 20, see paragraph 10.
Yes.
Thus, learned special part for ED has also submitted a present IA filed in this case is not maintainable, as the same has been filed by the wife of the applicant and not by the applicant himself. He has also submitted that as per 2F of Physical Economy
Yes, this was
Offender
also considered yesterday, you argued it, this
Yes.
Professor Gogoi's case.
Yes.
Yes,
Now, operative portion kindly see, my lord.
yes.
My lord, at para 20, at
Yes.
page 23, para 20,
Yes.
it does not require more than a common sense to be understand that reference to warrant of arrest in section 2F of Fugitive Economic Offender Act 2018 would mean an effective warrant of arrest which can be executed. It cannot be understood to include even a warrant of arrest which is under suspended animation. If the same is allowed to happen, the order of the court by which the warrant of arrest was kept in suspended animation would become inefficacious.
Correct.
Moreover, the notice referred to section 10(1) of the Fugitive Economic Offender has to be sent to the individual who is alleged to be a fugitive economic offender for his appearance at a specified place and time, and it is only on failure to appear on the said specified day, place and time that such an individual may be declared as fugitive economic offender. However, the instant case by order dated 24/10/2024, notice which was issued to present applicant appears to be notice of filing reply in hearing on an IA number 791 of 2024, and it was not for his personal appearance at a specified place and time as mandated under section 10 of. Thus, for the aforesaid reason, it appears that the applicant has a good case where there is a probability of getting a favorable order in the connected criminal appeal. Hence, during the said pendency of the said the impugn order so and so is here stay. So this is the order that has been passed, my lord. Now, straight away, the judgment which I referred, that's what I want to show that. Two judgment only. 1984, 4 SCC page 657.
Yes, that one and
And 1976 Delhi 246.
correct, this Anuradha case.
Yes.
Yes.
Just quick, my lord.
Yes.
If your lordship looks into Supreme Court judgment, para 14.
Para 14 of?
14 of 1984 4 SCC, my lord.
Yes.
That is Sudarshan Chits.
Para
See
14,
para 14.
Para 14, yes.
I just read para 14, my lord. However, see para 14.
Yes, Lord.
However, the narrow question which is required to be considered in this appeal is whether the winding up proceeding where pending or has come to an end when the appellant bench forced the winding up order by keeping it in abeyance. Let it be made at once clear that the winding up order made by the learned judge company. Now, my lord will kindly see the fact that after 1, 2, 3, 4, 5, 6, 7 lines, the fact that appellant bench has logic got it?
Yes.
They have directed the pending the implementation of the scheme as sanctioned by High Court, winding up order will be kept in abeyance itself without anything more shows that the order was neither cancelled nor recalled. Here, same, my lord. See whether it cancelled or nor revoked nor set aside. It continued to exist but was inoperative. Any default on the part of the company in carrying out its obligation scheme by itself without anything more would revive the winding up order. Therefore, winding up order was effectively subsisting but inoperative for time being, having all the potential of being regenerated or being brought back to life. Now, if the winding up order was merely para 15, held in is abeyance, that is, was not operative for the time being, but it had not ceased to exist, the winding up procedure in fact pending, and the court which made up the winding up order would be the court which is winding up the company. It is now well settled that a winding up order once made can be revoked or recalled, but till it is revoked or recalled, it continues to subsist. That is the situation in this case. If the winding up order is subsisting, the court was made that the order or the court which kept in abeyance will have jurisdiction to give necessary direction so and so to take recourse to section so and so. So this is the judgment which has been I pointed out. And another is, my lord, Delhi High Court, the para 14, my lord. See para 14.
Yes.
Para 14. It is obvious that Mr. Sidhu, learned additional district judge, was not feeling happy with the delay that the wife has been causing in production of her evidence, and he found that her continuing to get maintenance while prolonging the proceedings and not producing the evidence amounted to abuse of the process of the court. He therefore directed the order for maintenance would remain in abeyance. The question for determination is whether this order amount to rescission of the maintenance order and total deprivation of the amount of maintenance to the wife for the said period, or it amounts to temporary suspension and mere postponement of the payment. The learned judge has used the word abeyance. This word, according to Webster Third New International Dictionary, means temporarily inactivity or suppression, cessation or suspension. The temporary expression abeyance is equivalent to suspension, which means temporary withholding, temporary forced withdrawal. In my opinion, learned judge has used the expression abeyance in the same sense as been used in Hawkesbury Laws of England by expression suspension temporarily. The word suspend or suspension temporarily implied that the suspension is for temporary period and on the cessation of the suspension order or fulfillment of necessary conditions, the original order revives without any further direction. There are numerous instances to illustrate the effect of suspension. But this is what, my lord, what do you mean by abeyance, keeping in suspension? That, my lord, the Delhi High Court, in concerning the judgment that has been laid down by Supreme. So these are two judgments. I don't want to trouble to the judgment of our High Court, which has been already is in the IA, where it says, yes, the wife also can
do it.
Yes. So these are my humble submission before this honorable court. They have not complied. They could not have filed. 24/10/2024 application could not have been filed because that
So
day
certain statutory compliances, pre-compliances are not has been
have not been done.
That is your.
So this is the second. First is, man, they could not have filed that application on 24/10/2012 because at that relevant time the warrant, there was no warrant which was pending. So 2F. And second, which is most important, the criminal prosecution, I did not avoid it. It was represented by the lawyer.
Yes.
He represented.
That is that.
Yes.
That you have.
Yes. So these are my submission, my lord. Yes. So on this ground, my lord, the criminal appeal, my lord, declaring me as a fugitive offender should be set aside. That's my humble submission for this court. Yes. So I'll raise this because these are two important major cases. Yes. My learned friend will give a reply to these two, my lord.
Yes.
Yes. And after that, if necessary, we can give a response to that, my lord. I think that's my submission before this court, my lord.
Yes, Mr. Raju.
My lords want me to argue the FAO first or the other NBW matter first?
It's your choice. Any of those.
Now, my lords may kindly have a look, my lords. First, I'll deal with the part of abeyance which my learned friend has argued in two.
Yes.
I'll come to the Delhi High Court judgment which my learned friend stopped abruptly, did not read the remaining part of what he was reading. Kindly come to that and then I'll start, my lords. My learned friend was reading para 14, my lords.
Yes, para 14, yes.
It is obvious that Mr. Sidhu, learned additional district judge, was not happy with the delay that the wife had been causing in the production of her evidence, and he found her continuing to get the maintenance, but prolonging the proceedings and not producing the evidence amounting to abuse of the process of the court. Therefore, directed that the order of maintenance would remain in abeyance. The question for determination is whether this order amounts to recession of the maintenance order or total deprivation of the amount of maintenance to the wife for the said period, or it amounts to temporary suspension, mere postponement of the payment. The learned judge used the word abeyance. This, according to Webster's third New International Dictionary, means temporary inactivity or suppression, cessation, or suspension. The expression abeyance is equivalent to suspension, which means temporary withholding, temporary forced withdrawal. In my opinion, learned judges use the expression abeyance in the same sense as been used in the Halsbury laws of England by the expression suspension temporary. The word suspended or suspend temporary imply that the suspension is for a temporary period, and on the cessation of the suspension order or fulfillment of the necessary condition, the original order revives without any further directions. The original order revives. My lords, there are numerous instances where in law where a workman is suspended or in government service, an employee is suspended. In those cases, unless the suspension culminates in the removal or dismissal, the original contract of service or the status of the government servant revives on cessation of the suspension. We may peruse with advantage observations Supreme Court in Khemchand, where the court observed that an order of suspension of a government servant did not put an end to his service under the government, and he continued to be a member of the service in spite of the order of suspension. Therefore, the order continues despite the order of suspension. The real effect of the order of suspension was that though he continued to be a member of the government service, he was not permitted to work. There was no basis for thinking that because the order of suspension he ceased to be a member of the service, therefore the non-bail warrant ceased to be in existence, can't be there. Further, when the order of dismissal was set aside, the service revives. We are also familiar with the orders of the court suspending injunction, execution decrees, and other orders, all of which revive on cessation of suspension. So the result is that suspension or abeyance of the order does not amount to complete disbarment, but the operation order is only suspended or put inactive on the cessation or revives with its full vigor without any further orders. Revives its full vigor right from the inception. Revised with full vigor without any further. It is therefore clear that the learned additional district judge did not intend to absolutely rescind the order or to completely deprive the wife of the amount of maintenance. It does not amount to recall. Now, my lords, may kindly have a look at my note, my lord. I have given a written submissions note. My learned friend has referred to Sudarshan Chits, but kindly have a look at Sudarshan Chits is in my favor. Kindly have a look at para 22 of my written submissions, where I have extracted para 14 of Sudarshan Chits.
Para 22.
22 of my written submissions.
Yes.
Extracted Sudarshan Chits.
Yes.
However, the narrow question which is required to be considered in this appeal is whether the winding up proceedings are pending or had come to an end. So if I may say, non-bail warrants were pending or they came to an end. I'm just changing the words. When the appellate company froze the winding up order by keeping it in abeyance, let it be made that clear that the winding up order made by the learned judge in respect to the appellant company has neither been paused, set aside, cancelled, revoked, or nor recalled. So when it is abeyance, it is not recalled. This goes to the root of the arguments of my learned friend. So when an order is put under suspension, it is not recalled, it is not revoked, it is not cancelled, it is not set aside, it is not quashed. On the contrary, after directing that the winding up shall be held in abeyance, the appellate bench directed that the official liquidator shall continue to act as provisional liquidator as provided in section 450, and that itself is a stage in the winding up proceeding. When the winding up order is abeyance, it is in a state of suspended animation. The fact that the appellant bench directed that pending the implementation scheme as sanctioned by the High Court, the winding up order will be kept in abeyance itself without anything more shows that the order was neither cancelled nor recalled, nor revoked, nor set aside. It continued to exist but was inoperative. Therefore, non-bailable warrants were in existence. They may be inoperative for the temporary period. Any default on the part of company in carrying out its obligation under the scheme itself without anything more would revive the winding up order. Therefore, winding up order was effectively subsisting. I may say non-bailable warrants were effectively subsisting, but inoperative for the time being, having all the potentiality of being regenerated or being brought back to life. Now, if the winding up order was merely held in abeyance, it was not operative for the timing, but it had not ceased to exist. Therefore, the non-bailable warrant did not cease to exist merely because they were kept in abeyance. The winding up proceedings are in fact pending, and the court which made the winding up order would be the court with the winding up of the company. It is now well settled that a binding order once made can be revoked or recalled, but it is revoked or recalled, it continues to subsist. So abeyance doesn't mean it is revoked or recalled. It is in abeyance, but the existence is not deprived. Existence doesn't become inexistent merely because it is kept in abeyance. Then, my lords, may have a look at the next judgment which I've extracted of Supreme Court in C. Chamundi Mopeds. Para 10 I've extracted in para 23, my lord. My lords have got it?
Yes, yes.
3 SCC, page 1. While considering the effect of an interim order staying the operation of the order under challenge, a distinction has to be made between quashing of an order and a stay of the operation of the order. Quashing of an order results in the restoration of the position as it stood on the date of passing of the order which has been quashed. The stay of operation order which does not have a lead to such a result. It only means that the order which has been stayed would not be operative from the date of the passing of the order, but it does not mean the said order has been wiped out from existence. Abeyance is just like a stay. Delhi High Court, relying on this judgment of Sri Chamundi Mopeds in CC Space Telelink Limited in Para 9 as well. It is apparent, therefore, Para 9 of Delhi Telelink, Space Telelink, Delhi High Court. The apparent, therefore, in order keeping in abeyance the judgment of a lower court or authority does not deface the underlying basis of the judgment itself and its reasoning. Then, my lord, this honorable court in Qasem Ali Ahmed in para 14, which I have extracted at page para 25. The meaning extract of the word abeyance in Black's Law Dictionary, temporary inactivity, suspension, as per Oxford Dictionary. So and so, abeyance means a state of temporary disuse or suspension. This court is of the considered view that when the so and so operation notification bearing numbers was kept in abeyance without anything more, the operation of notification was in a state of suspension from that date. The notification status cannot be held as cancelled or revoked or recalled or set aside. It has to be held, notification continued to exist but was inoperant. Therefore, non-bailable warrants continued to be in existence. Therefore, the content non-recalled is palpably incorrect. It was also noted the order dated 5/9/24 was hedged with the conditions petitioner would. That is on the next point, my lords. As far as the hearing point is concerned, I'll come to para 26.
Yes.
I'll read para 20 anyway. Therefore, the contention that non-bailable warrants should be recalled is palpably incorrect. It must also be noted the order dated 5/9/24 was hedged with the condition that petitioner would prepare personally. The petitioner has not challenged the said order or the said condition therein. Therefore, he cannot now seek to partially rely on an order which is favorable to him and disown that part of the order which is inconvenient to him. Party cannot be permitted to appropriate and reprobate. Now, my lords may kindly have a look at the Fugitive Economic Offenders Act.
Yes.
Now, kindly have a look at definition section 2F.
Yes.
Fugitive economic offender. My lords have got it?
Yes.
Means any individual against whom a warrant for arrest in relation to scheduled offence has been issued by any court in India. That a warrant has been issued, there's no dispute. It has been issued in relation to scheduled offence, not in dispute. By any court in India, not in dispute. The only issue is whether the warrant ceases to be in existence because of an abeyance order. That's only on the date of the application, not on the date of the order.
Now, another issue, Mr. Raju.
Yes.
Thing is that he is already in custody in India.
Now, not at the time when the order was passed.
Correct. Now, what happens to that now? Now, since he's there in your custody. So, what will be the effect of that?
After that he has come, then the act he will have to apply under the provisions of the act for whatever it is. But that is not in question before my lords. Today the issue is whether the order of declaring a fugitive offender on the date it passed was valid or not. That's the issue. What happens after it is passed is not an issue, not in question before this honorable court.
No, that the only thing is that now the order has been passed declaring him as a fugitive, correct?
Yes.
Whether rightly or wrongly, that this court is
According to me, it's rightly, my lord. I'll point out it's rightly.
The court is going to examine that. But the position is that now he's under custody. So how this 2F will be applicable to him now?
The 2F applies at the stage when the order is passed, not subsequent. Fugitive offender can always come back. It is not that he is fugitive for all times to come. That's not the law.
The correct, that I understand, but now what will be the effect of the order that he has been declared fugitive, but now he's within
Then his
now,
the properties will be taken care of. The consequences of his being declared a fugitive economic offender will follow.
whether the order declaring him as fugitive will still subsist when he
Yes,
is already in
yes.
custody.
He can apply, come and then come and make an application.
Now, in the changed circumstances, whether this court can look into it.
Kindly have a look at section
Submit on
11.
that.
Kindly have a look on that. That stage has gone. Section 11, procedure for hearing, that stage has gone. He has been declared. Section 11 stage is gone. Hearing is to be contemplated. Section 12 stage is gone because it's been declared. Now kindly have a look at section 12 to consequence. On a declaration under subsection 1, the special court may order that any of the property stands confiscated to the central government. That is consequent to that stage has not yet come in this matter.
I mean, this order has been challenged here.
Instead
Correct.
of that, he could have applied under 11.1. Therefore, also this appeal becomes infructuous in a way. No, yes, I'm sorry, I'm sorry.
Yes, yes, yes.
Easier to notice has been issued, appears in person at the place and specified, the special court may terminate the proceedings if he appeared before the order was passed. So the necessary consequence is that the properties will be confiscated. Now I'll come to the law. Then, my lord, what happens is really not in question before this honorable court. What is in question before this honorable court is the order was wrongly passed. The court had no jurisdiction because he was not a fugitive offender. As defined at 2F, because the non-bailable warrant was in abeyance, therefore there was no warrant in existence. That is his case. That is wrong. Prima facie wrong, thoroughly misconceived. Because of the requirements of 2F. What is the requirements of 2F? A question which I am putting to myself. There must be a non-bailable warrant. That non-bailable warrant must be not at the date of the application, but at the time when the order was passed. At the time when the order was passed, even the order of abeyance had gone. May I give the dates, my lord? May I give the dates?
That's there. But what about section 10 compliances? Whether those things are complied?
Yes. There is no grievance as far as compliance is concerned. Notice, etc.
No, there is a grievance. There is a grievance. There is a strong assertion made that section 10 hasn't been complied with. Please.
That can be done. Notice to others that can be done at a later stage.
Let us state.
Yes, 12 to.
Let us see the statute, what it says,
Yes.
what it says.
Where kindly have a look at 12.2, my lords.
No, kindly come to 10.1.
Yes. When an application in section 4 has been duly filed, the special court shall issue a notice to an individual who is alleged to be a fugitive economic offender.
Correct.
The notice before the subsection shall also be issued to any other person who has interest in the property mentioned in the application under subsection 2 of section 4.
Whether this has been done?
Yes, according to me, the second part comes later. The first part to him has been done.
But I could not see anything that like this section 2 has to be complied later.
Just give me a minute, but I'll come back to that.
Yes.
Kindly have a look at the order.
Which order?
Order declaring him as a fugitive offender.
Yes, that is at page. Let us see, that is at page.
142.
142, yes.
My lords is saying 141, referring to 142, my lords.
Yes, 142.
Now kindly have a look at para 3
Yes,
at page 144.
yes.
The learned special PP submitted the accused was summoned on 6 occasions by ED in the course of investigation, but the accused never appeared before the investigating agencies. This honorable court had also issued summons to the accused in connection with instant case number so and so, but the accused has never appeared in person. So the hearing is the only issuance of notice is not appeared. If a person is absconding, look at the definition, is staying abroad. Despite that, notice has been issued. He doesn't choose to appear.
But his appearance has been exempted on all the dates. That there is an order in existence.
Appearance exemption exempted, yes. But if he has to appear, he has to appear. If the court says despite exemption, court can always ask an accused to remain present. And the court had asked him to remain present and did not remain present. Therefore, the non-bailable warrant was issued.
He did not remain present, but subsequently order was passed stating that his personal appearance is exempted because the lawyer appeared for him. That order is available in the record, on the record. I don't know whether you have gone through that order or not.
Exempted for the day. Kindly have a look at the order at page 39.
Page 39, yes.
Kindly have a look.
Yes.
IA number 506 in revision number 3 of 25, my lord. He was exempted from personal appearance for the court for a day.
Correct. Was there any order for his personal appearance again in that order?
Yes, there is an order which says he should be personally remain present. He doesn't remain present.
No, when he was exempted, or for the
Kindly have a look at page number, my lord. Page number 66.
Page 66.
3 of 25.
Page 66.
Yes. No, not this. The earlier one. The earlier order. I'm sorry. Just give me a minute. Order very clear, asked him to remain present and thereafter the non-billable order did not. 592. Yes, ma'am. Kindly have a look at page 29.
Yes.
13, 12, 24, the impugned order.
Yes.
Learned counsel Amit Singh present for accused 124 297 also filed exemption application for accused 13 and so and so. With regard while disposal of IA number directed A1 to be present in person. So there was a direction for him to remain present in person. Lawyer can remain present provided there is no such direction. If there's a direction for the accused to remain personally present, he has to remain personally present. He cannot say I appeared through a lawyer.
Then which order you are referring to?
I'm referring to 13, 12, 24.
13, 12, 24 page.
Page 29.
Page 29 is 24.
Criminal revision.
Petition 3 of 25.
Criminal revision 3 of 25. He's referring.
He is referring to which one you are referring?
Criminal revision 3 of 25, page number 29.
He's referring to criminal revision, my lord.
Yes.
So we have not taken up criminal revision. We are taken up this criminal appeal.
I'm referring to that was argued probably yesterday.
Right. I mean, now you are referring to page 29 of the criminal revision.
Yes.
Wait a minute.
Second paragraph, Manoj, of the order. My lords have got it?
Yes. So, so you are referring to order dated 13/12/2024.
Yes, my lords, I'm applying.
Yes, and there a personal appearance. Okay, let's see, where is that?
First paragraph, second paragraph.
Second
May I read
paragraph.
the paragraph? Learned counsel, Sri Amit Singh, present for accused so and so, filed an exemption application so and so. Since with regard to accused number one, he is accused number one. This
Correct.
court had wide order dated 5/9/24 while disposing of the IA 53 of 24. Is that 5/9/24 order? Directed A1 to be present in person.
Yes.
So there's a specific direction to remain present in person. That was flouted. That resulted in the non-bailable warrant to be issued.
Now let's see the subsequent orders. When he did not appear before the court.
5/9. Kindly have a look at 5/9 order, my lords. 5/9.
5/9 order at page.
I'll just remember. Page 66.
That's why I've given a spiral binding. That's because easier.
Last paragraph at page 66.
No, one second. Just a minute.
Never challenged.
My lords have got page 66.
One second. Yes, page 66.
Last paragraph.
Yes.
The ED will be reheard on the next returnable date, which is fixed on 18/10/24. ED is to supply a copy of the application to the accused petitioner through counsel. Meanwhile, the non-bailable warrant issued against the accused petitioner, namely Bhupesh Arora, is kept in abeyance till the next returnable date. Accused petitioner is to be personally present on the next date.
Yes.
This order of 5th of September is not challenged. So direction to remain personally present issued by the court, not challenge the present petition, present proceeding.
Yes, I mean, on the next date, what happened? Let us see.
And then kindly have a look at what he has prayed for. Page 24. Restore that order of 5/9/24. My lords have got page 24. Kindly have a look at prayer C.
Page 24, where? Prayer 3.
Prayer C.
Prayer C, restore the interim order with the so-and-so extended to so-and-so till.
Restore the interim, therefore, that order says personally remain present. All those judgment, Indra Swami, Goswami, etc., there was no direction to remain present. Therefore, a person who is directed to remain present doesn't remain present. The court rightly has issued a non-bailable warrant. It is not a case where a complaint has been filed. Bhaskar Industries, which was read, was a 138 negotiable instruments case. And my learned friend argued that the summons tribal case is totally wrong. I'll demonstrate it's not a summons tribal case. It's a warrant tribal case.
So that, I would like to hear your submissions on that.
Yes, I'll come to that a little later. Therefore, my court may kindly have a look. This is a case where the warrant has been issued because despite the direction of the Honorable Court to the petitioner or the appellant to remain present, he chose not to remain present. Therefore, the court issued a non-bailable warrant. My lords have got it? Now, coming back to the Fugitive Economic Offender Act.
I would just like one clarification here. The accused petitioner is to be personally present on the next date, correct? After this order, of 5/9/2024, which was the next date?
1810,
So what was the order passed in 1810, let's see?
nothing as such, members. It's not there. No.
So 1810 to 24 order, let's see.
Then there's the next date.
It is at page 42.
Yes, madam.
Page 42 of this revision.
Yes, madam.
So it says learned counsel Sri Amit Singh present for accused number 1, 2, 3, 4, etc. So 1 is the accused here. I mean,
Kindly have a look, my lords, at page number 43, but last paragraph onwards.
Yes, yes.
Learned counsel Sri Amit Singh appeared for the accused number 1. As apprised this court that IA summons is pending dismissal, whereby the complaint is filed NBW for accused number 1.
Correct.
The learned counsel submitted the copy of the IA has not been served. The special PP submitted before this court. The copy will be served today before so and so. For accused, let IA be listed on 12/12/24. Meanwhile, interim order shall be continued till the next date. With
Correct.
regard to the execution of bail bond compliance order of this court, special submitted the only one accused. Number 106 has executed bail bond in compliance with the order of the court. I perused the record accordingly. Final report is granted the accused person to execute bail bond, failing which warrants will be issued. With regard to the accused person who have been represented by the LENCA, the personal appearance has been exempted for today. Available warrants.
So what is this? What is this, Mr. Raju? With regard to the accused person who has been represented by their learned counsels, their personal appearance has been exempted for today.
Yes, exempted for today, yes. But that is not with respect to the persons who are asked to remain personally present.
How can you say that?
Those are not.
See,
It is only for that particular date.
I mean, learned counsel Sri Amit Singh present today for so and so. Then subsequently it has been stated that with regard to accused person who has been represented, in this case Amit Singh has represented by their learned counsels, their personal has been exempted today.
For today, for exempted only for one day. Exempted for today, not exempted permanently.
So was there any order stating that he should be present on the next date? Personal appearance? If there is something, then please show it.
13 years. Yes, yes. Kindly have a look at page 44. Fixing on 13/12/24 for appearance. Last line of that order. 13/12/24 for appearance. Appearance means physically present.
So there are some variances in the orders. In some orders, the learned trial court says personal appearance. In some orders, he says appearance. Now this is very.
But this got adjourned on a technical objection that the copies was not, the IA copy was not given. Otherwise, he had to remain present. He did not remain present. The issue is not that. My lord, kindly have a look, Mother. The issue is not that the non-bailable warrant was wrongly issued. The issue is whether the non-bailable warrant was in existence when it was in abeyance, and whether the order in the Fugitive Economic Offenders Act could be passed. That's the issue. The order issuing non-bailable warrant has not been challenged, that he could not have issued that 5/9/24 asking my appearance. That is not under challenge before this honorable court in the Fugitive Economic Offenders Act matter.
The only issue is the court wants to examine whether once the NBW was kept in abeyance, then after that, what was the cause, why it was activated again? In spite of the.
That is not an issue before the.
No, that court has to examine.
It's not a jurisdictional issue before this honorable court.
The court has to examine.
That he has to challenge. That has nothing to do with the Fugitive Economic Offenders Act matter. That may be with respect to the other matter of the court that they could not have issued non-bailable warrant. That is a separate proceeding. This proceedings, as far as Fugitive Economic Offenders Act is concerned, the warrant was issued. The warrant was in existence. Abeyance order was not in existence when the order was passed. Therefore, kindly have a look at the dates, my lord.
Yes.
Order of the non-bailable warrant is 2724.
You are referring to some compilation?
I'm referring to the dates, my lords.
Dates from where?
Dates from the proceedings.
And is there any compilation you have given on that, or like I mean?
Opposite side has given, my lords. Start of their pleadings. I'll give the page numbers, my lord.
Yeah, please give me the page number so that I can refer to.
Criminal, this is, my lords, criminal revision application number 3 of 25. Kindly have a look at the list of dates given by my learned friend.
Yes, in the very beginning.
Yes.
Yes.
That kindly have a look at the date 2nd of July 24.
2nd of July 24. Yes. Yes.
Will file petition number so and so, intended praying for issuance of non-bail warrant against the petitioner. Learned court was pleased to allow the prayer of the respondent as further pleased to issue open-ended non-bail warrant for arrest to the petition appellant in his absence. So 2724 is the order when the non-bail warrant was issued.
It was off day.
Come to the 5th September or date, my lords.
Yes.
That was the date when this non-bail warrant was kept in abeyance, not recalled, not quashed, not set aside. It was only kept in abeyance. My lords have got it?
Yes.
5th September.
Yes, yes.
And then we filed the application for declaring him to a fugitive economic offender on 24/10/24. Kindly have a look at the date.
24?
10/24.
Yes. 24/10/2020. Yes.
The non-available warrant was in abeyance, but not withdrawn, not cancelled, not.
What was this? I mean, what was this? There was one application filed by the appellant 507.
I am referring to dates which are relevant as far as I am concerned, my lord.
Yes, you have referred to the dates for your concern, but the court is also concerned with certain dates.
Yes, my lords are referring to
that's why I wanted to ask you
yes.
that application for one second. The application of application that IA number 531 that you have referred to.
IA 531 is by them.
Yes, so it was filed by the appellant, whereby IA 230 was filed by you.
Yes.
It was direct to be reheard. It was directed to be reheard.
Then 791 was filed by us, which is the F number.
That was for issuance of NBWs, my lords.
230.
So there was an order subsequently that that IA number 531, no, IA number 230 of 2024 was scheduled for rehearing.
Maybe, yes.
So whether it was reheard again, because NBW was issued under an order issued in IA number 230. And 230 was supposed to be reheard. So once an order for rehearing is passed, so whether the court
subject to the condition that he appears personally. If he doesn't appear personally, there's no question of rehearing. Or maybe the rehearing is pending. That doesn't make any difference. Whether the rehearing was pending, not decided because he did not appear personally. There are two things. My lords may kindly note two things.
Yes.
There is a non-bailable warrant.
Yes. Which was in kept in abeyance? correct?
Non-bailable warrant
Non-bailable warrant, captain abeyance, correct?
in abeyance.
Yes,
What is requirement of a fugitive requirement of offender is the non-existence of a non-bailable warrant.
correct.
On the date when the order is passed. So on the date when the order is passed, was there a non-bailable warrant in existence? If the answer is yes, then the order is not without jurisdiction. Because the order of non-bailable warrant is not set aside merely because it is set out for rehearing doesn't make the order of non-bailable warrant vanish. The order is in subsistence. My lords may kindly appreciate. The order is in subsistence, the order is in existence, the order is there. If the order is there,
So learned trial court will pass whatever order he feels like passing. He will say that I will rehear you, then he will not rehear that. Then he will kept it abeyance and he will reactivate it of his own. I mean, is this the way the learned trial court really conducts?
my lord, that is not. The issue is how the accused is conducting himself. That's the issue, not the issue of the trial court.
Yes, I have seen this. His appearance was exempted.
For one day it was exempted. One day it was exempted. My lords may kindly have a look. It was not exempted for all time. He was asked to remain present, doesn't remain present. My lords will also examine the conduct of the accused. It's a 22,000.
Yes. There's absolutely that has to be. That definitely.
There's a 22,000 fraud, 22,000 fraud where innocent people have been duped.
Yes. That court will definitely keep.
Now kindly have a look at the order of 1312. Why the non-bailable warrant was issued?
Yes, 1312 order.
Yes. Because he failed to comply with the direction of the court. What was the direction of the court? To remain present.
1312 order is at page.
Page 29.
Page 29. Yes.
Thirteen 12 order says, I asked you to remain present. You don't remain present. Therefore, you compelled me to issue a non-bailable warrant. Personally present. Therefore, one can't find fault with the trial court. What can the trial court do? Ask him to remain present. He doesn't remain present. And the declaration of FEO comes after what, 22nd January 25. So the bailable warrant was in existence since 13/12/24. There was no abeyance order after 13th of December 24. There was no abeyance order of any non-bailable warrant. So on the date when the order of the fugitive economic offender order was passed, there was a non-bailable warrant which was not even put in abeyance, which was not even recalled, which was not even set aside, which was not even cancelled.
Correct. That I have.
Therefore, now have a look whether the provisions of the FEO have been complied with.
Yes, section 10. That I would like to hear you on that. Whether it's let us see how the order was passed. As far as notice under section 10. Where is that list of other persons, connected persons? It is in the revision and appeal. Criminal
Notice was issued to all 78 interested parties, my lords. 178 in interested parties. Those are my instructions.
55, correct, 50, so this is what filed.
This is the application under section 4. It starts at page 54.
Yes, Mr. Raju, can you come to page 54 of the
May I
appeal?
read from page 48 onwards, my lord. I'll come to 54.
So this is the application, this is the application.
No, this order, my lords. I'll read from page 50, then I'll come back to that. My lord, kindly have a look at page 54. IF 791 of 2024, my lord.
54 of the revision, right? Yes.
54 of the appeal.
Yes, 54 of the appeal, yes, that is the application that you have filed.
Yes, now what is the order on the application, whether the impugned order declaring, now may I read from the beginning at page 48, my lord?
Page 48.
The order dated 22nd of January 25.
Page 48 of criminal appeal is something else probably. Okay, second page, it starts from 47.
It starts on 47.
Yes.
Finally come to page 48.
Yes.
The instant IA pertains to application of section 4, read with section 10 and 12 of the fugitive.
From where are you reading?
First para of the order.
At page 47?
48.
There is.
I'm in criminal revision 3 of 25. I'm sorry, but
That's what I've been saying.
Page 143.
Page?
143 of the appeal.
He's referring to 143 of appeal.
Yes, the order, that order. Yes. That's what I wanted to see, yes.
Instant IA, my lords have got instant IA.
Yes.
Pertains to application of the section 4, read with section 10 and 12 of the Fugitive Economic Offenders Act 2018, seeking declaration of the accused respondent as fugitive economic offender and confidence. Both the counsels were heard on the date fixed for hearing on 14/1/25 and the order of hearing follows. So he was heard. Who was the counsels, my lord? For the ED as well as Hemang Shah along with Amit Singh, he was the advocate. We can't say that.
They have been heard, yes.
Therefore, we can't say no notice was issued.
Yes,
Learned special submitted at the threshold the instant application filed by DD so and so, authorized by director so and so. On the other hand, learned a counsel for the accused contained said notification authorizing the director pertains to the date prior to coming in force of the said act came into force only on so and so. The notification does not grant any authorization to deputy DD under section 10. Learned PP submitted that the accused was summoned in 6 occasions by the ED in the course of investigation, but the accused never appeared before the investigating agencies. Honorable court is also issued.
Just for a second, I'm just sorry for interrupting you. Just for a second. I mean, before you read this, you have submitted that notice has been served. So there should not be any submission on behalf of the appellant that
notice has been issued. I did not say served. I said notice has been issued.
Notice has been issued. Yes. Now let us see what is the statutory notice under this section.
No, kindly have a look. There's nothing like a statutory notice. Kindly have a look at this, my lords.
No. Let us go to section 10 first.
Very well. If my lords permit me to, my lord, let me make my submission.
Because you have submitted that notice is issued. So no complaints should be made on the notice.
Section 10.
So we wanted to see that whether what kind of notice is this? Section 10.
Page number 10, my lord. Where an application
section 10 notice.
The filed notice to an individual. Notice means if a person makes a grievance before my lords that no notice was served, therefore there's violation of section 10, that's a different thing. But when he appears through his lawyer and argues the matter, where the question of non-compliance of section 10, that even if there's a requirement that would be waived, but say he has been heard. Now I'll read. Let me read it, and the provisions will be clear. My lords are preempting me, but kindly have a look at what does section 10 says. Issue a notice. The purpose of the notice is to hearing. The fact that his lawyers have appeared would obviate the requirement of issuing notice, but anyway, page 153 says notice has been issued. He also files a reply. Therefore, where's the question of issuing a notice? He files a reply.
And notice in usual course and notice which has been statutorily provided, mandated, whether that has been complied or not, this court has to examine. And Mr. Raju, you'll have to satisfy me that he'll have to satisfy me that notice has been served as per the statute.
How can he take that point that no notice has been issued to me? Can a person who has been heard through his lawyer appeared, filed a reply? Can he say no notice was issued to me?
And that is why I just want to that is why I want myself to be satisfied.
Person who has not been heard can say no notice was issued. But the person who has appeared, filed a reply and argued, can he say that no notice has been issued?
Okay, I'll take it that as per you, that notice is issued. Correct.
Because he has appeared.
Fine. Then we'll go back to the order 22-1. Yes.
Therefore, now I'll also find out whether he's raised this contention. The person who appears, files a reply and argues, can't take up a contention that no notice has been issued to me.
Correct.
But in any case, the notice has been issued. That is my submission, my lords.
Yes.
Notice is for the purpose of hearing. A person who is absconded living in a foreign country. Therefore, the legislature has used the word issued and not used the word served. Because a person who is staying in foreign country absconding, there's no question of serving him.
Yes, that's true.
Now, my lords, may kindly have a look at the order, my lords.
Yes.
Para 3 I was reading. Learned special PP submitted the accused was summoned on 6 occasions by the ED in the course of investigation, but the accused never appeared before the investigating agencies. Honorable Court has also issued summons to the accused in connection with the incident case, but the accused has never appeared in person. As such, non-bail bonds of arrest was already been issued against the accused, which is pending execution as the accused have absconded and reportedly left the country now in Dubai. Accused have also approached the Honorable Apex Court in Delhi as well as Gauhati. However, the same was withdrawn. Accused have approached the Honorable Gauhati High Court with a prayer to quash all criminal proceedings and the same is pending. Accused have not joined in investigation till today. Per contra, learned defense counsel submitted the accused was charge sheeted without being arrested, not been shown as absconder in the charge sheet. Final complaint filed by ED. Further submitted, accused have not have entered appearance through counsel, and this honorable court has granted exemption to the accused personal appearance. Accused have been taken recourse to legal remedies before competent court and show cause will and to show that the will and intent of the accused to face trial. Accused has been out of the country before prosecution was launched and have not refused to return to India. The special PP also further submitted the requirement of FEO has been complied with. All the preconditions contemplated in the act have been fulfilled, justifying declaration of accused of fugitive economic offender. Per contra, learned defense counsel submitted instant application of premature and not maintainable. The list submitted by the complainant is incomplete and apparent from the fact averred by the applicant. They are still in the process of identifying Benami properties owned by the accused. It was further submitted that the time when the notice of FEO was issued, notice under FEO Act was issued. My lords have got it. That is his contention. Under the FEO Act, cannot be termed as fugitive economy. Therefore, he admits that notice under FEO was issued.
Further, the notice is issued not in conformity with Section 10. That was his.
Under the FEO. There's no question of conformity, my lord. Section 10 only contemplates hearing. He says, kindly look at again the submission. Accused It was further at the time when notice on the FEO Act was issued. Where does it say that it was not in conformity with the provisions of the FEO Act, Section 10? That is not his contention.
That was he, that has been specifically stated by him. See the last line.
Yes. Further, notice is not in conformity with Section 10 of the FEO Act.
That is the specific thing.
There my lords are right. Not in conformity with Section 10 of the FEO Act. How it is not in conformity with Section 10? It doesn't say. How it is not in, merely saying that it is not in
Yes.
conformity with Section 10. His cases, others have not been issued notice that he can't have a grievance. Others may come and appear, my lord. Where is it?
No, not only the thing, Mr. Razu.
Yes.
His pleading, his specific argument was also that notice is in not conformity to the mandates of the Fugitive Act under Section 10. That was his specific argument. And in addition to that, his argument was that notice as per Section 1 of 10 was not issued.
I accept it, my lord. Let us see his contention. How it was not in conformity with Section 10, my lords? Question which I am asking myself, which is not on merely by saying that it is not in conformity with Section 10 will not suffice.
Because Section 3 says, 10.3 says, notice under subsection 1 shall require the individual to appear at a specified place and time not less than 6 weeks from the date of issue of such notice. What his submission is that this is not complied with.
I'll tell my lords with this. That is, my answer to this is twofold.
Yes.
Number one, my lords, as far as the notice is concerned, that would apply to a person who has not appeared pursuant to a notice. The person who has appeared and argued the matter cannot take up the contention that the notice is bad. Then it pales into insignificance. What prejudice has, the question is what prejudice has been caused to him? There has to, he has to plead and prove prejudice. It's a very hypothetical. Let us assume that a notice. Now kindly have a look at page 153, my lords, before I go to the submissions which I was making.
Yes, 53. Yes.
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 Fourth line, the respondent was given notice contemplated under Section 10(1) of the Act and the respondent appeared through learned advocate provided under the 11(2) of the Act. There's an order.
Precisely, that's why this has been, this has come before this court.
The order says it has been issued. Let us assume, my lord, there are two things. Order says it has been issued. Therefore, when an order is passed, it will be presumed that what is stated in the order is correct unless my learned friend demonstrates that the order is wrong and it's a wrong has been made. He has not even applied to the court that no such order has been passed. Now I'll tell the second submission arising out of this. Supposing an order under Section 10 is not issued, I'm assuming, I'm not admitting it because the tribunal says the court says it has issued it. Therefore, I presume that it has been issued. What is the purpose of the order? The purpose of the order is to afford hearing. Has he been afforded hearing? Yes. A person who has been afforded hearing and appeared in the proceedings, can he take up the contention? Notice was not issued to me as technical contention. He is barred from raising such a contention. Any such right, if any, has been acquiesced or waived.
Yes.
Secondly, orders cannot be set aside unless there is prejudice has been caused. Kindly have a look at Section 465 of the CRPC.
CRPC.
My lords are aware
Give me the CRPC.
that even under administrative law, the earlier law was, if hearing was not afforded, the order is bad, you need not prove prejudice. That was the old line of thought as far as administrative law is concerned. Now they say, no, you have to prove prejudice. Whether it is administrative law, Ridge versus Baldwin, and has taken a turn. Forget what Ridge versus Baldwin case. Kindly have a look at 2021 19 SCC 706.
Yeah, you are referring to a section of CRPC.
I'm coming to that, Manoj. I'm referring to administrative law principles, also CRPC, Manoj. I'll
Yes.
come back to CRPC. First, kindly have a look at 2021 19 SCC 706. I don't have the compilation, but
What is the citation?
2019, just a bit. 2021 19 SCC 706.
You have a copy of
The
this?
three-judge bench of the Supreme Court.
You don't have any copy. No? Library. You can have. 1 second. I just tell him to get it.
Till he gets it, may I come to 465, my lord? Ask him to get Vertigo and all those kind of things.
Yes, 465. Yes.
Subject to the provisions herein before contained. My lords have got it?
465. Yes. 465 CRPC. Correct.
Yes.
Yes. That finding or sentence.
Yeah, finding reversible reason of error, omission, or irregularity.
Correct.
Not issuing notice may be an irregularity. Subject to the provisions herein before contained, no finding, sentence, or order passed by a court of competent jurisdiction shall be reversed or altered by a court of appeal, confirmation of revision, or on account of any error, omission, or irregularity in the complaint, summons, warrant, proclamation, order, judgment, or other proceeding before or during trial or in an inquiry or other proceeding under this code, or any error, irregularity in any sanction for the prosecution, unless in the opinion of the court that failure of justice has in fact been occasioned thereby. So an order cannot be set aside on the ground that notice has not been issued unless there has been failure of justice. Failure of justice means he must demonstrate prejudice. That is Vertigo's judgment. Of course, I am aware that this is criminal procedure code. Provisions of criminal procedure code may not strictly apply to fugitive economic offender, but the principle is this. And then therefore I'll come to the administrative law also. That for an order to be set aside, it cannot be set aside on mere technicalities, but prejudice must be proved and established.
Okay.
465 has been interpreted by the Supreme Court in Vertigo's case. The citation is 2021.
Yes, 2021.
2021, 2 SCC 525, paras 23 and 27.
Yes.
Now in para 23, after they referred to one or two judgments of the Supreme Court, their lordships said
I don't have the copy of the, just a second,
My
second.
lords have got 20, the first judgment, my lord, which I have said.
First judgment I have,
I'll come to the
2021.
first judgment, my lord.
Yes, 2021, 1966, yes.
Kindly come to para 39 of the judgment.
Para 39, yes.
My lords, in the meantime, if it is possible, but I'm so sorry for the call
No,
for
no.
the book Vertigo also, my lords. The other judgment.
As to just get this 2021, 2 SCC 525. 2 SCC 525.
525.
525, yes.
There are 39, my lords have got it.
Para 39.
Yes, in Aligarh Muslim
Yes.
University
Yes.
versus Mansoor Ali Khan, the aforesaid authorities were relied upon, and the answer given was there is no absolute rule, and prejudice must be shown depending on the facts of each case as follows. The principle that in addition to breach of natural justice, prejudice must also be proved has been developed in several cases. K.L. Tripathi also laid down the principle that not mere violation of natural justice, but de facto prejudice other than non-issue of notice has to be proved. It was observed, quoting so and so, it is not possible to lay down rigid rules as to when the principle of natural justice are to apply, nor as to their scope and extent. There must also be some real prejudice to the complainant. There is no such thing as merely technical infringement of natural justice. Requirements of natural justice must depend on the facts and circumstances, the nature of inquiry, rules under which the tribunal is acting, subject matter dealt with, so forth. Since then, this court has consistently applied the principle of prejudice in several cases. The above ruling and various other rulings taking the same view have been exhaustively referred to in State Bank of Patiala versus S.K. Sharma. In that case, the principle of prejudice has been further elaborated. Same principle has been reiterated again in Rajendra Singh versus State of New. And the useless formality theory, it must be noted, is an exception apart from the class of cases or of admitted or indisputable facts leading only to one conclusion referred to above. There has been considerable debate on the application of that theory in other cases. The divergent views expressed in this theory have been elaborately considered by this court in MC Mehta referred above. The courts surveyed the views expressed in various judgments in England, Rod Reed, so and so, in various cases, and also expressed by leading writers, Professor Gardner, so and so. Some of them have said that the orders passed in violation must always be quashed, for otherwise court will be prejudging it. Some others have shown that there is no such absolute rule and prejudice must be shown. Yet some others have applied via media rules. We do not think it necessary in this case to go deeper into ultimate analysis. This may depend. In Union of India, allowed this court after eschewing a hyper-technical approach held that prejudice must not merely be in the apprehension of the litigant, but should be a definite inference of the likelihood of prejudice following the refusal to follow natural justice as follows. Earlier, in some cases, this court has taken the view that breach of principal natural justice was itself a prejudice and no other de facto prejudice need to be proved. In regard to statutory rules, the proponent view was the violation of mandatory statute would tantamount to but where the rule is merely directory, the element of de facto prejudice needs to be pleaded and shown. With the development of law, rigidity of these rules is somewhat relaxed. In the instance of de facto prejudice has been accepted as an essential feature that there is violation of non-mandatory rules or violation of natural justice as it understood in common parlance. Taking an instance in a department inquiry where department relies on large number of documents, majority of which are furnished, and the opportunity is granted to the delinquent officer to defend himself, except that some copies of formal documents have not yet been furnished to the delinquent. In that event, the onus is on to show that non-furnishing of these formal documents have resulted in de facto prejudice and has been put to a disadvantage as a result thereof. So non-issuance of the notice has put him to a disadvantage. He must plead and prove.
But this is a case of personal liberty.
No, this was nothing to do with personal liberty.
Yes,
personal liberty, it is still stricter.
Yes.
Notice the existence of laws.
Para 39, 40, and any other paragraphs?
This is the same. This is the paragraph. Now kindly come to Vertigo.
44, yes.
Vertigo, the next judgment.
The next judgment, yes.
So if an order has to be set aside, they must plead and prove prejudice. That's the principle.
Correct. So this you have, okay, then Para 39 and 14, 202119 SSC, and this other case, 40 co, para
Para
20 and
23.
27.
Para 23. Kindly have a look at para 23.
23, yes. Yes,
After section 460 was extracted,
yes.
kindly look at placentum, between placentum D and F after the quoted paragraph. It is provided that finding of sentence passed by a court of competent jurisdiction would not be set aside merely on the ground of irregularity if no prejudice is caused to the accused. It is not disputed that this question was neither raised by the accused at the trial nor prejudice was pleaded either at the trial or at the appellate stage, and therefore, in the absence of any prejudice, such technical objection will not affect the order of sentence. So he has to prove prejudice. A person who appears, argues the matter, and cannot say no notice was given to me. It would be travesty of justice. I can understand a case where a person doesn't appear. I could not appear because no notice was issued. I can understand that. But a person who appears, argues the matter to the hilt, and then can he say, no, I was not issued notice? Let's see the reply. Has he raised this in his reply? Then kindly have a look.
Yes.
Now kindly have a look at para 27. In the present case, there are no pleadings by the public servant with regard to prejudice caused to them on account of non-obtaining of so-and-so prior consent for specific petition. That was on the facts of the case. So there has to be pleadings. What prejudice has been caused to him?
Para 27.
Yes, of vertigo. That he has to plead prejudice. He's not with me, my lords. I'll go through the reply and see whether it is in the trial court, in the FUA application.
Yes.
Therefore, my lords may kindly have a look. As far as he is concerned, he cannot raise this play because it appeared. Even if there was a right, it would be deemed to have been waived. This is my contention, my lords, as far as that is concerned. In any case, notice was issued, and non-issuance of notice in the form required under section 10 is not, it did not vitiate the order. The ultimate purpose is that he has to remain present and argue when the time when the application is being heard. What is the purpose of giving the time and date? That you must be able to appear on the time and date when your application is being heard. That was complied with because he appeared on the date and the time when the application, and in fact, he made submissions on the date when the application was being heard. Therefore, this hyper-technical submissions, contentions should not be permitted in the case of this magnitude of this looking to the magnitude of this economic offense. 2,200 crores of poor people have been siphoned off. Now, kindly have a look at the second point. Therefore, this point regarding notice, I have addressed, notice has been issued. Even if it is issued in the, it's only a mere irregularity, does not vitiate the proceedings, even if it is not issued as per section 10, because the requirements of section 10, the purpose of section 10 has been complied with in this case.
Right.
Now, and now kindly have a look at the second submission, my lord.
Yes.
Kindly have a look at section 2F first.
Yes.
Fugitive economic offender means any individual
Yes.
against warrant of arrest in relation to a scheduled offense has been issued by any court in India. So warrant, non-bail warrant has been issued. There's no dispute with respect to scheduled offense, no dispute by a competent court in India, by a court in India, no dispute.
Yes.
Only dispute, he has left India, no dispute. They are only concerned with the first part. His objections are with respect to the first part. Two F doesn't say that an offense, the non-bailable warrant which is in existence, kept in abeyance, 2F will not apply. I read the judgments and shown Your Honor what is the meaning of abeyance.
Yes,
Abeyance
that is
means
argued.
that non-bailable warrants are washed off. They're effaced, they're settled, but they're issued and they're in existence. Temporarily stayed, yes, but they're still in existence. Till they are set aside, the non-bailable warrant is in existence. Those are the judgments which I've shown to my lords.
Yes, so
Now,
it
now
was,
kindly have a look at, kindly have a look at the date of declaration of FU 22/1/2025.
yes,
That date, there was no order of abeyance. On the date when the court passed the order under the Fugitive Economic Offenders Act, there was no order keeping even the non-bailable warrants under abeyance. The non-bailable warrants were issued on 13/12/24. The non-bailable warrants which were issued on 13/12/24, there is no order even of abeyance of those warrants. Kindly have a note, man. Kindly have a look at this. Now come to section 10.
yes.
12.1. Declaration.
Section 12.
12, yes. Declaration fugitive economic offender.
Yes,
After hearing the application under section 4, if the special court is satisfied that an individual is a fugitive economic offender, I have read the definition of fugitive economic offender.
yes,
He is a fugitive economic offender means on the date of the declaration. Now take a case, my lord, take a case. If what my learned friend is canvassing that it is on the date of the application that he should be the non-bailable warrant should not be in abeyance. Supposing, my lords, take a reverse case. On the date when I file an application, there is a non-bailable warrant which is issued. But on the date when the declaration is made, that order is cancelled. Question which I'm asking myself, can the order be passed? No, because what is crucial is the date when the declaration is made, when an order is passed under section 12, not the date of the application. The date of the application, let us assume. Therefore, supposing it is there at the date of the, it is there at the date of the application and not there at the date of the order, no court can pass the order. Therefore, 12 has to be read in those contexts that he has to be an fugitive economic offender on the date of the declaration under section 12.
yes, there is no dispute in this. Yes, that's
Therefore, on the date it was there, he was a fugitive economic offender. That's the end of the matter. Now, as far as other notices are concerned, he is not appearing for the other notices. They will come and they will, when they appear, we'll make the submissions on that. 12.2 also takes care of those notices. There are two stages. One, a declaration, then hearing as far as property is concerned. No order has been passed prejudicial to the other two. It's only a declaration of fugitive economic offender. There's no order of confiscation of properties. Others are not to be declared as fugitive economic offenders. If anybody has a right to any property, he can come and apply. 12.2 hearing will be given before confiscation. Therefore, it's a two-step process. One is declaring a person to be a fugitive offender and then confiscating his property.
so confiscation order is not ordered, hasn't been passed. So
At the time of passing the confiscation order, all those who are interested can come and appear and say, yes, this is there. This is not that is not the property of the fugitive, it is our property. We are not so stupid to attach somebody else's property. If there is somebody who is legitimately claiming the property, the court will look into it.
So yours basically on this point, your submission is that as far as notices to other persons, affected person that you have listed, that
Not
since
affected at this stage. They will be affected when the confiscation is made. If at all the property belongs to them, that 12 to contemplate that hearing, my lords.
so confiscation order hasn't been passed, so they are not
Yes.
affected.
Therefore, it's a two-step process. One, because confiscation order can be passed only if it's declared as a fugitive offender on declaration. Kindly have a look at subsection 2 of section 12.
Yes.
On declaration of subsection 1, the court may order that any of the following properties stands confiscated to the central government. So it is only the declaration has to come first. Confiscation has to come thereafter. It is not that confiscation has to be done immediately. No hearing has been done on confiscation. The order doesn't deal with confiscation. The order deals with only the first part, that declaring him as fugitive economic offender. Now this finishes my submissions as far as the fugitive economic offenders matter is concerned. Now I'll come to the non-bailable warrant part for this. Kindly look at my written submissions.
Yes. So this one is concluded, right?
Yes,
From your
this
side?
appeal part is concluded.
Appeal part is concluded. Yes.
We let it complete.
Yes. Now this revision one.
Yes. Kindly look at my written submissions.
Yes.
I'll briefly take my lot to the written submission so that it will be faster.
Yes.
Kindly have a look at the nature of the fraud, my lords. Para 1.
Yes.
Herein the main accused case, the ECR number so-and-so, based on predicate offense so-and-so, allegations pertain to how gullible investors were duped with promises of astronomically high returns on investments in Bitcoin mining to an app-based token called HPZ token. Further, FIR number so-and-so was also registered for cheating and criminal conspiracy under section so-and-so, so-and-so, relation to scam. These FIRs and CBI case so-and-so against related entities established huge fraud was perpetrated on the public by HPZ token app and associated schemes. That the offense involves duping lakhs of investors under the false pretext of high returns from Bitcoin mining and other investment schemes. The amounts collected from victims across India, aggregating over 2,200 crores, constitute procedural crime within the meaning of section 2(1) of the PMLA, have been generated from scheduled offences of cheating and criminal conspiracy. ED's financing has traced this illicit funds into multiple accounts of assets, quantified assets for 652 crores, which have been attached and frozen. The prosecution complaint dated so-and-so is filed. The petitioner did not appear pursuant to 6 summonses issued. That the prosecution complaint itself said they did not appear. He was cooling his heels in Dubai. He could never have appeared. And under section 50 of the and further invest was kept open for him. Relevant portion of the prosecution complaint extracted here in para 8.33 that during investigation summons dated 13/1/23, 22/2/23, 1/5/23, 27/9/23, 18/12/23 and 21/2/24 were issued to Mr. Bhupesh Arora, Director of Freebie Solutions Private. However, under section 50 subsection 2 of the PMLA.
But one second, for a second, just for my clarification, this dates 13/1/22, these were prior to the cognizance was taken, right?
Yes.
That was by the investigating authority.
Prior to the prosecution, it is part of my prosecution complaint. It
Yes.
is in the prosecution complaint.
Yes, no, is there, no, what I am asking is that whether these dates were issued by the by the courts or like investigating authority.
By the investigation, our summons under section 15(2), PMLA summons 15(2), 52 are the summonses issued by us.
Yes.
Our case in the prosecution complaint, when we filed the prosecution complaint, is that he never appeared, never cooperated. We could not investigate him. Despite that, we filed the charge sheet.
Yes.
Of the complaint. Then, my lords, that is page 121 of the PC. My learned friend will hand over the copy of the prosecution complaint, if he is there.
Yes.
Then para 12, further investigation pending in the case. During course of investigation, it has been observed that scam is very huge. This is para 12 of my PC, my lord. Only a part of the proceeding of time has been detected and placed under freezing attachment. further investigation in other unearth further proceeds of crime, and hence investigation needs to be continued. The investigation in respect of OS confirmed and have been completed, and the same were completed on the basis of available evidence. Our investigation in respect to other part of proceeds of crime, as discussed, is still continuing. Further investigation section under PMLA in the case continues to trace the trail of remaining proceeds of crime. Role of other persons in the offense of money laundering. Complaint reserves the right to file supplementary complaint if required at a later stage. Filing of a supplementary complaint is now allowed under Section 44 of the PMLA Act. Therefore, it permits further investigation. We have said out of 2,200 crores, we have only traced 657 crores. Remaining to trace the remaining, our investigation is pending. Then my first, these are the facts. That further investigation is pending. Person is absconded, staying in Dubai. We have filed the complaint because if we don't file, the impression was if we don't file the complaint, the proceeds, the attachment lapses. Therefore, we had to file it on technical reasons. Not that because the investigation was complete. Unlike a charge sheet where it is filed only on because the complaint, because the investigation is over. Here, investigation was pending, and we have stated that in our prosecution complaint. Now, my lord, the first submission is person summoned under Section 50 of the PMLA is bound to appear in person. It is well settled that when a person is summoned under Section 50, subsection 2 of the PMLA, the person so summoned is bound to appear in person and state truth upon subject concerning which is being examined or is expected to make statement. Director of Enforcement during course of inquiry is statutorily empowered to issue summons to persons for the purpose of inquiry and seek adducing of a material evidence necessary for the inquiry. When summons are issued, there is a legal obligation the person summoned to comply with the summons and appear. Reliance is faced in the case where Enforcement Directorate was the state of Tamil Nadu, where the Supreme Court has held in para 6 as follows. From bare reading of the said provisions, it is clearly transpired that the concerned officers, as mentioned therein, have the power to summon any person whose attendance he considers necessary either to give evidence or produce any record in the course of investigation or proceedings in the PMLA. Since the petitioner ED is conducting the inquiry investigation under the PMLA in connection 4 FIR number so and so, so and so, so and so, I'll turn the page, my lord. Registered and so district person to whom summons are issued under section are obliged to respect and respond to the said summons. Then, my lord, Delhi High Court judgment in Veerbhadra Singh, the powers, para 140, the powers conferred on enforcement officers for the purpose of complete and effective investigation include the power to summon, examine any person. Law declares that every such person who is summoned is bound to state the truth at the time of such investigation process. The person summoned is not an accused. We are recording that. Then, my lords, may kindly have a look at para 6.
Yes.
Where Amanatullah Khan's judgment has been cited of the Delhi High Court. After Section 50 of the PMLA, powers of Director of Enforcement summon any person while taking note of the observation made by the Honorable Apex Court in case of Vijay Madhulal, this bench in the case of Maulik Ghatak and Director of Enforcement has made the following observation: power of Director to issue summons to any person the consequent duty of such person to attend the same. The observations are extracted here and that I must put, my lord. But then, my lord, non-bailable warrants can be issued even after filing of the prosecution complaint for securing presence of the accused during further investigation. That's the second point.
Yes.
Even after filing a prosecution complaint, courts can issue non-bailable warrants for securing presence of the accused during further investigation. Honorable Supreme Court case of Dinesh Dalmia, so and so, para 19. A charge sheet is a final report. Complaint is akin to a charge sheet in the case of PMLA, my lord. Police investigation is a charge sheet, otherwise it's a prosecution complaint in the case of PMLA. Charge sheet is the final report within the meaning of subsection 2 of 170 of the code. It is filed to enable the court to consult to apply its the provisions of the offence thereupon should be taken out. The report is already filed in the form prescribed. Therefore, one of the requirements of it is that whether the offence appears to have been committed, and if so, by whom. In some cases, the accused having not been arrested, the investigation against him may not be complete. There may not be sufficient material for arriving at the decision that the absconding accused is also a person by whom the offence appears to have been committed. If the investigating also finds sufficient evidence even against such an accused who has been absconding, in our opinion, the law does not require that filing of a charge sheet must await the arrest of the accused. Indisputable power of the officer to make prayer for making further investigation in terms of subsection 8 is not only taken away, only because charge sheet under subsection 2 thereof has been filed. Further investigation permission even if the order of cognizance of offence has been taken by the magistrate. Then, my lord, Delhi High Court in Lakshay Wage, para 7. Learned Special Counsel submits so far as the order dated 5/10/24 is concerned, as detailed in the grounds raised in the petition Dinesh Dalmia, Supreme Court has held that IO need not await presence of an absconding accused to file a charge sheet against him. Further, in Tarsim Lal versus Director of Enforcement, Supreme Court has also clarified it is available to ED to seek custody of an accused whether appeared after issuance of summons for conducting further investigation in the same offence, and the court is empowered to pass appropriate orders on such a request. In the light of the extant position of law as enunciated by the Supreme Court, Interpreter Dinesh Dalmia and Tarsim Lal, the court is persuaded to agree with the submissions made on behalf of the petitioner, namely, merely because prosecuting complaint has been filed by the ED without tracing, arresting, or arresting accused Karan Chok, that is not in itself a ground to assume that ED has been derelict in investigating the case. Furthermore, the law is also clear that custody of an accused can be sought even after filing of a charge sheet or a complaint. Therefore, there was no error committed by the learned tribe by issuing open-ended non-bail warrants after recording the following facts. See page 49 of the complaint. Registered under so-and-so police station, so-and-so. Same would be investigation for the PM and the district collectors and other person in some other issue. This, I'm sorry, I am reading the wrong case. Peruse of the ECR shows that there is a prima facie case against the accused Bhupesh Arora for the offences as alleged against him. As submitted by the learned SPP, the record shows the summons under section 52 were issued to the accused on 6th date, but he never appeared before the investigating officer. So he did respond via email to summons dated so-and-so, citing a medical reason, and the last summons dated so and praying for a few weeks' time, he never appeared before the IO. Even the order dated 25/9/23 passed by the Honorable Gauhati High Court in Kohima bench in rate petition filed with the accused, when the accused was directed to cooperate with the investigation, was never complied with by the accused. As such, from the aforesaid, I am satisfied the accused is not cooperating with the investigation and is proved before the investigation is necessary. I will shown that the accused is absconding and station to buy the prayer for the applicant is being allowed. So reasons, elaborate reasons have been given for issuing a non-bailable warrant. It is not a case like Indra Goswami where a private complaint is filed and the magistrate straight away issues non-bailable warrant. The facts are grossly different. Then third, the issue of Tarsim Lal applies only to power of arrest under section 19 of PMA, does not apply when the court is issuing a non-bailable warrant. It is submitted that no hearing is contemplated to a person before issuance of non-bailable warrant, even if a prosecution complaint is filed, for the reason that non-bailable warrant of arrest issued by a court is different from the power of arrest by the Directorate of Enforcement of Section 19 of the PMA. Arrests are of two kinds. Arrest under warrants issued by a court, arrest otherwise than under such warrants is placed in judgment of State of Punjab as Ajay Singh, Supreme Court. Broadly speaking, arrest may be classified into two categories, namely arrest under warrants issued by a court, arrest otherwise than under such warrants. Apart from the Code of Criminal, there is no other statute which provides the arrest and execution of warrant of arrest issued by a court. Apart from the Code of Criminal Procedure, there are other statutes which authorize the arrest of a person without a warrant issued by any court. Reference by way, for example, may be made to Section 173 and 173 of the Sea Customs Act, Section 64 of the Forest Act. In both the cases, the reason for the arrest is that the arrested person is reasonably suspected to have been guilty of an offence and under the Act, and there is provision in both the cases for immediate production of the accused person before a magistrate. Two things are to be noted, namely that in cases of arrest without warrant under the Code of Criminal, and arrest without warrant under this Act also proceeds upon an accusation that the person arrested is reasonably suspected of having committed offence. There is no provision for communicating to the person arrested the grounds for his arrest. Turning to Article 22(1) and 2, we have to ascertain whether it is protection extend to both categories of arrest mentioned above. If not, then which one of them comes under arrest? But there can be no manner of doubt the arrest without warrant issued by a court or for greater protection than do arrest for such warrants. Then, my lord, no hearing is contemplated before issuance of a non-bailable warrant. It is submitted that neither Section 73 nor 70 CRPC stipulates that the court issuing a non-bailable warrant must first issue a prior notice to the accused. Similar argument was rejected by the Honorable Delhi High Court in Sukhmeet Singh. challenging the impugned order, contention of the learned counsel for the petitioner is that the claim of the complaint for jurisdiction vested in Delhi police to register the FIR or the two courts to try the case is bogus. Charge sheet has been filed on 8th November 2017 in FIR 93 of 2014 without, however, no cognizance has been taken till date. Admitted till date, the petition has not been served with a notice in the absence of whereof no bail warrants could be issued against the petitioner. That is the contention. The notices were sent to somewhere Delhi address of petition where admittedly the investigator was aware that petitioner is not in India, residing in Spain. The issuance of non-bail warrants is contrary to guidelines issued by Minister of Home Affairs, and thus non-bail warrants issued against the petitioner are required to set aside. Learned counsel for Indian additional standing counsel for state submits that petitioner has not joined the investigation till date. Petition seeking quashing of FIR were filed by the co-accused before this court, which such petitions were dismissed by the court on so and so. The further states that the petition filed an application seeking recalling of non-bail warrant issued by the learned ACMM placed before the court ordered the Honorable Supreme Court exempting the managing director of Samsung stating the petitioner Supreme Court was exempted from hearing by the order of the apex court. London ACMM thus cancelled the non-bail warrant issued against the petitioner and allowed the application filed by the petitioner when complete. Facts were brought to the notice of the court that the order of exemption by appearance only related to Lee, managing director of Samsung, who was purported accusing the complaint filed as Ghaziabad fresh non-bail warrant seeking cancellation non-bail warrant were dismissed by the impugned order. London additional standing counsel claims petition making false claims that at every stage and have not joined the university till date and non-bail cannot be cancelled. Then, my lord, kindly have a look at the next para 10. Content of the learned counsel for the petitioner since no notice has been served on the petitioner at his address in Spain that the issuance of non-bail warrants against him is illegal, is also rejected. As noted above, the petitioner is a citizen, Indian citizen having Indian passport and his permanent residential address in so and so Delhi. Only when he was convicted in Dubai and directed to be deported thereafter, the petitioner, by misrepresenting the fact, got his new passport issued from the Embassy of India, Spain, giving a local address. Merely because the petitioner has not visited India is no ground to come to a complaint. Petitioner has no contact with his permanent resident somewhere. As noted above, from the investigation carried out, it is evident the petitioner committed the alleged offence. Thus, the learned trial court was within his jurisdiction to have issued non-bail warrant with the same further petitioner with the jurisdiction of the court through his attorney. The main plank of the argument of the
2 minutes,
is that in the absence of service of no non-bailable warrants could be issued against the petitioner. Said argument is fallacious, required to be rejected. Decision reported so and so. Allahabad High Court dealing with the power to issue process under so and so, it may be observed. But as per the scheme of criminal procedure, once an FIR disclosing non-bail offence is registered against the accused, police are empowered to interrogate the accused in that connection, even to arrest him. However, if an accused tries to evade the arrest, police can also ask issuance of non-bail warrants. However, when non-bail warrants are not executed because of evidence of the arrest by the petitioner, the court is empowered to issue process by 82, which is the process to ensure appearance of petitioner in the court so that the investigation can complete. When an accused is not available to investigate, despite his notice that his permanent address, in a case of cognizant non-bailable the investigation, which is offense of serious nature, even without service of notice of the investigation within the industry, an order seeking issuance of NBW for the therefore serving of notice is not required. Trial court has jurisdiction to and power to issue non-bail warrants of arrest during further investigation.
I think this point was not argued by them. This was not. Is this the point you argued? No. This point is. In fact, they have not argued on this point.
Then I will. But kindly have a look. Supposing is my lords, if the that's the data point. Then he is not. Then I'll go to the next point, my lord.
Yes.
He was not.
Because that was not argued by them. They have not.
Right.
Yes, six may be relevant.
Kindly have a look at para 18.
Para 18. 18 of?
Of my written submission.
Para 18.
1.8.
Yes.
It is submitted that even in the order dated 5/9/24, could accept the petition since prosecution complaint has been filed, and the law laid down by the Honorable Supreme Court in Parsimlal versus ED will have to be followed. Issuance of non-bailable does not tantamount to granting ED custody. It is precisely for this reason that the order dated 5/9/24, the non-bailable ones were kept in abeyance during the petitioner's personal appearance. It is only when the petitioner failed to appear that the non-bailable ones which were earlier kept in abeyance were directed to be executed. It is pertinent to note the present petition does not impugn on the order dated 2/7/24 by which an NBWs were issued or 5/9 does not impugn the orders of 5/9/24 in which non-bailable were kept in abeyance and the petition was directed to appear physically. They have not challenged those two things. Further, learned, he has in spirit complied with the requirements of the law laid down in Mohan Goswami, because he has asked him to remain personally present. Therefore, law in Mohan Goswami will not apply, because that was a case where a private complaint was filed and straight away the warrants were issued. This is a case, this is a different, huge economic offense. Then I'll deal with what is summons and warrant tribal case. Pausing here for a moment, kindly have a look at my lords. The CRPC. I'll pause here with my written submission. Kindly have a look at the Code of Criminal. What is a warrant tribal case? And I'm shocked that this submission has been made. Kindly have a look, my lord.
Yes.
First warrant case at 2x.
Where?
CRPC. My lords have got it.
Yes, CRPC, yes.
Kindly have a look at section 2x where a warrant case has been defined.
Yes.
Warrant case means.
One second. Yes.
Warrant case means a case relating to an offense punishable with death, imprisonment for life, or imprisonment for a term exceeding 2 years.
Yes.
So, if the offense is punishable with more than 2 years, it is a warrant case.
Yes.
Now, summons case, my lord, which is W.
Yes.
Summons case is a case relating offense not being a warrant case. So if it's less than 2 years, then
Yes.
it's a summons case. Now kindly have a look at section 4 of the PMLA, my lords.
One second. One second.
It is 7 years.
Section 4 of PML. One second.
What is the punishment? 7 years.
Yes.
Whoever commits an offense of money laundering shall be punished with rigorous imprisonment for a term which shall not be less than 3 years, but which may extend 7 years and shall be liable for fine. Therefore, it's a warrant case. Warrant case, triable as a sessions case. Kindly have a look, my lords. At section 44, 1D.
Section 44, 1D.
Of the PMLA Act.
Yes, section 44 under, yes.
Special court.
Yes.
Special court, but trying the scheduled offense or the offense of money laundering shall hold trial in accordance with the provisions of Code of Criminal as it applies to trial before a court of session. So it's a session tribal case, which is a more aggravated form of case. Now kindly have a look, my lord. Kindly have a look now, my lords. At section 204 of the CRPC.
204, yes.
Mohan Goswami was concerned with the initial stage when the process was issued. I'll take not at the later stage, as in the present case, where an accused is asked to remain present, doesn't remain present. Issuance of non-bail warrant has nothing to do with issuance of process at the initial stage. My lords are having 204.
Yes.
Issue of process. Even the opinion of magistrate taking cognizance of an offence, there is sufficient ground for proceeding, and the case appears to be a summons case. He shall issue summons for the attendance of the accused. This is not a summons case. Warrant case, he may issue warrant if he thinks fit a summons. So warrant case, the first he has to issue the warrant and not a summons. Summons for causing to be brought to appear to a certain case before the magistrate if he knows some other magistrate having jurisdiction.
But he has a choice here. I mean.
He has a choice, but this is not a magistrate exercising powers. This is a special court exercising powers. Now kindly come to.
Yes.
So this is not, now kindly come to the facts of Inder Mohan Goswami. 2007-12 SCC page 1.
You please give me the cases that has been referred, that printouts.
I'll refer to it, Madam.
Yes, para.
Now kindly have a look, my lord. I'm showing the facts, my lord.
Yes.
Just give me a minute, my lord. FIR was quashed in this case, my lord. Kindly have a look at the. This was a case where the offence was not made out. The court quashed the FIR, my lords.
Yes.
Now kindly come to my lords. Para 15.
Para 58.
15, 1-5.
1-5.
On the basis of FIR registered, case was investigated by Sub-Inspector Ravala Police Station. Later, investigation was transferred to the Rishikesh Police Station. Thereafter, investigation was again transferred to Raiwala Police Station. Charge sheet was filed in the court of special judicial magistrate, Rishikesh. This was a case of a matter before a special judicial magistrate, Rishikesh. This was challenged by filing a quashing petition.
Yes.
Then, my lords, may kindly have a quote at para, my lords. Para 22. The veracity of the facts.
Once again, para 22. Yes.
Veracity of the facts alleged by the appellants and the respondents can only be ascertained on the basis of evidence and documents by a civil court of competent jurisdiction. The dispute in question is purely of civil nature. Respondent 3 has already instituted a civil suit in the court of civil judge. In the facts and circumstances of the case, clearly initiating criminal proceedings by the respondents against the appellant is clearly an abuse of process of the court. Therefore, it was and misuse of the process of court, civil dispute.
That was one of the grounds.
Things.
Yes.
Then my lords may kindly have a look, my lords. It is in the background by the magistrate head, my lords.
Which case file?
Now kindly have a look at what their lordships have said in paragraph.
Indermohan Goswami. Which paragraph?
Para 51.
Para 51.
Issuance of non-bail warrants involves interference with personal liberty, arrest and imprisonment means deprivation of most precious right of an individual. Therefore, courts have to be extremely careful before issuing non-bail warrants. Liberty is precious, etc.
So it has laid down where non-bailable warrants should
What
be
is
issued.
issued to bring a person to court when summons of bail warrants would be unlikely to have this desired result. He was asked to appear, he doesn't appear. Therefore, the court was justified in issuing non-bail warrant. In the first instance, the court said, kindly remain present. He doesn't remain present.
So you are trying to distinguish with Indermohan Goswami by saying that he has been repeatedly asked to appear. Personally, he didn't appear. So the facts of the case in Indermohan and in the instant cases are different.
Yes, even the court asked him to remain present, he did not remain present. The
Correct.
court says, first instance, did the court issue a non-bail warrant? In the first instance, the court said, please come. Kindly have a look at para 47. Before parting with this appeal, my lords have got it?
Yes.
Parting with it, we would like to discuss an issue in which great public interest, how and when warrants should be issued by the court. It has come to our notice that many cases bailable and non-bailable warrants are issued casually and mechanically. In the instant case court without properly comprehending the nature of the controversy. Nature of controversy is civil nature. No offense, offense is quashed. Without exhausting the available remedies, issued non-bailable warrants. The trial court discharged readily enumerated in the following two cases. The facts, Ombati, without going to the facts of the case. So what are the facts of the case show? 2,000 crores of poor public has been duped. The man is cooling his heels in Dubai, doesn't appear in 6 summonses, doesn't respond, doesn't appear when the court asks him to appear. Therefore, the court was thoroughly justified in issuing non-bailable warrants.
So facts are distinguishable.
Yes, gross facts.
Yes.
Now kindly have a look at the judgment of Supreme Court in Anda's case, my lord. Kindly have a look.
Which one? Which one?
That is, my lord. 2025 SCC Online 764. Aditya Sardas case.
Page 17 to
Page
2025 SCC Online SC 764.
1 second. Page
18.
764.
Starting from page 18.
Second copy. Where is the second copy?
Yes.
It's already there, Your Lordship.
Page 18.
Yes, starting from page 18 to 24, 42.
Okay, page 18. Yes. That's serious fraud investigation case.
Yes. Versus
Yes.
other 25. Now kindly have a look, my lord.
Yes.
At 53. Kindly first have a look at para 28.
Para 28. Para 28, yes.
A faint attempt was made by learned counsel for respondents to rely upon the decision of, in the case of Tarsim Lal, to submit that if the respondents were not arrested by SIF during the course of investigation in the filing of the complaint, the special court, while taking cognizance of the alleged offences, should have issued a summons only to respond and accuse and not a warrant. The said submission is bereft of merits. As this was earlier, as per section 204 CLP, in a complaint case which appears to be a warrant case, court taking cognizance of offence has the discretion to issue warrant or summons as it thinks fit for causing the accused to be brought to appear before it. As held by three-judge bench of this court in Inder Goswami, this court is empowered to issue even non-bail warrant to bring a person to the court when it is reasonable for the court to believe that the person is not voluntarily appear before the court, or the police authorities are unable to find the person to serve him the summons. There cannot be a straitjacket formula as sought to be submitted by the learned advocate for the respondent that court must first issue a summons given case of warrant case, irrespective of the gravity of seriousness of offence, as well as settled by now whether attendance of the accused can be best secured by issuing a bailable warrant or non-bail warrant should be a matter which entirely rests with the discretion of the concerned court. Although the discretion should be exercised judiciously, diverse considerations such as nature and seriousness of offence, circumstances peculiar to the accused, possibility of concealing or absconding, larger interests of public and state, etc., also must be seriously considered by the court. 6 summonses not appeared, cooling his heels in Dubai. Court asks him to remain present, doesn't appear. And seriousness of the offence, which is required to be considered, therefore, Inder Goswami's principles will not apply. And the court says, in a given case, even warrant can be straight away issued.
Yes.
Then, my lord, I was in para 20.
Para 20?
Of my written submissions.
Okay.
Furthermore, the learned special court has in spirit complied with the requirements law laid down in the Inder Goswami, since it not only recorded petitioner failed to appear pursuant to 6 summonses, but additionally kept non-bailable warrants in abeyance, giving petitioner further opportunity to appear in person. Despite such multiple opportunities, petitioner failed to appear, and NBW was directed to be executed by way of the impugned order dated 13/12/24. Then, my lords, NBW warrants issued by order dated 2nd July 24 were never recalled but merely kept in abeyance. This I had read, my lords. Abeyance. I'll read para 21 and then, my lords. The contention that the order dated 2nd July 24 has been recalled by the order dated 5/9/24 is erroneous. Section 70 subsection 2 of CRP expressly confers upon the trial court power to cancel the warrant of arrest issued by it. Power to cancel a warrant of arrest subsumes within it the power to give the warrant to appear. Well settled that when a court has the power to grant a filer, it can certainly mold an interim relief. It is wrong to interpret the order of 5/9/24 as an order recalling the order dated 2/7/24, wherein non-bailable warrants were issued. In fact, 10 ultimate para of order dated 5/9/24, it is accepted by petition, not challenge even the present proceedings, uses the expression non-bailable warrants to be kept in abeyance. Rather, prayer in the present petition seeks to restore this very order. I pointed out this prayer, restore this very order. An order which uses the expression NBW to be kept in abeyance cannot be read as recalling NBW, that is amount to adding words to an order which would not be impermissible. Whether or not the trial court could have passed such an order as passed in 5/9/20 is not subject matter of the present proceeding, since neither party has challenged the said order. In fact, there clearly permits ED to seek custody accused by applying to special court in terms of custom laws, which is stated earlier.
That you have already read, yes.
Then I have read all this, my lords.
Yes.
Then, my lords, Roman 7, appearance through an advocate cannot be treated as appearance before the court by a person against whom directions for personal presence has been issued. The petitioner's contention that he was appearing through a counsel, hence he cannot be said to be absconding, is liable to be rejected. Appearance through counsel, despite a direction by the court to appear in person, has been held by the Supreme Court to be of no appearance. Reliance is placed on judgment of the Honorable Supreme Court in Srikant Upadhyay. We are in full agreement with the view taken by the Gujarat High Court that filing of an anticipatory bail through an advocate could not be treated as appearance before a court by a person against whom such proceedings as mentioned above are instituted. The meaning of the term absconded has been dealt with by us herein before. We found that etymological, original sense of that is accused of hiding himself. What is required as proof for absconding is the evidence to the effect that the person concerned was knowing that he is wanted, and also about the pendency of warrant of arrest. Detailed discussion is not warranted in this case to understand the appellants were it was not in dispute that they were served with these summonses. The fact that bailable warrants were issued against them also not disputed. The appellants themselves have produced the order wherein the bailable warrants were issued against them. We have already referred to section 70 subsection 12 CRPC which would reveal that the position that once the warrant is issued, it would remain in force until it is cancelled by the court which has issued it or until its execution. There is no case for the appellants that either of such events is there is no either of the such events has occurred in this case to make the warrants unenforceable. They also got no case that their application was interfered by a higher court. That apart, it is a fact that the appellant themselves on 23rd of August 22 moved a bail come surrender application to the trial court, but we do the same fearing errors. It is also relevant to note that the case in hand, even while contending that they were before a court, the appellant got no case that in terms of provisions of 438(1), the order of the proceedings before the court was ordered either suo motu by the court or an application was public. That is on the facts.
Yeah,
Next,
that's right.
petitioner relied on order dated wherein his application for exemption of personal appearance was allowed. However, perusal of the order reveals that exemption person was allowed for that day. In any event, subsequent order dated 5/9/24 directed his personal presence, which he never challenged. It is well settled that the order, even assuming the nullity, has to be challenged in accordance with the law. Otherwise, it remains to be binding. Interstate parties' reliance is placed on judgment of Honorable Supreme Court in the state of Punjab. In some cases, respondents were dismissed from service may be illegally. The order of dismissal clearly infringed their right to continue in service, and indeed they were precluded from attending office from the date of dismissal. They have not been paid their salary from the. They came forward to the court with grievance that the dismissal from service was no dismissal enough. According to them, the order of dismissal was illegal, inoperative, not binding to them. They wanted the court to declare that the dismissal was void and inoperative, not binding on them, and they continue to be in service. For the purpose of these cases, we may assume that the order of dismissal is void, inoperative, ultra-virus, not voidable. When an act is void or ultra-virus, it is enough for the court to declare it to so it could as automatically it need not be set aside. Every party can simply seek a declaration that is void and not binding upon it. Declaration merely declares the existing state of affairs, does not quash the superior news, but nonetheless, the impugned order of dismissal has at least a de facto operation unless and until it is declared to be void and nullity. Therefore, the earlier orders of fine issuing non-bail warrants have not been challenged. Then my lords may seek para and 8, my lord. Trial before the Court of Sessions. That I've already read, my lord.
Yes, yes.
These are my submissions, my lord.
Yes.
These are my submissions. As far as these two other applications, as and when my learned friend argues, I'll make my submissions. Quashing, etc.
Yes. Those petitions are not heard today.
No,
being heard today.
those are not been
Or
heard.
only these two.
Yes.
Two petitions.
My lord, now today is 4:20 is not possible to give a reply because my learned friend has argued. So that I'll give a reply, my lord, in this case.
So when-
Not much, my lord, for 30-35 minutes.
When?
On Thursday in the morning, I'll give it. Thursday in the morning.
So
And will they argue the other matters, my lord?
Thursday in the morning.
whether you'll be available here.
If I'm available, no. Otherwise, I'll be on virtual, my lord.
Quashing may be de-tagged, my lord. Quashing may be de-tagged. Unless he wants to argue on Thursday.
No, Thursday there is an issue because
Yes.
by 12 o'clock this court will rise.
No, what
because-
I'll do, my lord, Thursday in the morning,
Yes.
10:30, I'll address before this court.
Because of because
Because there is a motion, my lord, my learned friend Thursday. Thereafter, I'll take half an hour to finish it of the matter, my lord.
20 and 21 may be de-tagged, my lord. Those quashing matters may be de-tagged.
Question
Why-
matter,
why
any
tag with this
it will be taken. It is not been tagged also. Not tagged question.
Quashing matters will be heard on a different date, Mr. Razu.
Very well. I have no objection.
Because
Yes.
these two matters I will decide. So let him submit his reply to your submissions. But whether tomorrow we can do it.
Tomorrow there is difficulty, my lord. I have to go back because I stayed. So that's the whole problem, my lord.
Okay.
He can give
Otherwise,
written submissions also, my lord.
I'll not trouble your lordship. It only with a half an hour. I will just conclude it, my lord.
Okay, then Mr. Raju, can we fix it on Thursday in the morning?
Morning I will have difficulty, but he may continue. But
Your junior can be there.
Yes. If there is any point which I have to address, I will address, or Mrs. Zoeb Hussain will address, my lord. Any one of us will address the issues.
But like that has to be done before 12 o'clock. That is the problem.
Yes, we'll do it.
12 o'clock this court is rising because
I'll do it, man. I'll do it.
that's right.
So this matter, complaint question is detached and will be Yes.
Which one? Which one?
This complaint case, that's a question of a complaint.
And that
We'll
is
be
only,
taking
I mean,
any other date.
those are not, listed.
Yes,
as
not
brief.
tagged, not tagged.
Separately listed,
yes.
separately listed.
Yes.
My presence and presence of my briefing lawyer, Mr. Zoeb Hussain, may be mentioned in today's hearing.
Yes, yes. Joy, Mr. Joy?
Mr. Zoeb Hussain.
Joy Hussain, yes, we'll do that.
Grateful.
We'll do that.
May I leave, my lords?
Yes, surely. So we'll fix it on
Thursday morning.
Thursday morning. Yes.
10:30, my lord, because there is a motion which I have to tell before Lordship that whether we want to withdraw it or what we want to do it, whether to proceed.
Correct. That is.
So that we will do it. Second, I'll just give a reply to what my learned friend has said.
So like he has pointed out certain things on.
That's a very important. I have to give a reply.
Sessions case. Then.
Yes. Whether it is a summon procedure, whether it is a warrant procedure. This thing I have.
So in both these matters, you write Mr. D. Das, learned senior counsel, assisted by Mr. S. Das, learned. I'll put your names also, but related Das for the petitioner. Also heard Mr. S. B. Raju, assisted by Mr. Joheb Hussain or something. It was there in the
Lordship, my name can be also reflected.
his name also. So assisted by so and so.
SPP.
The matter remained part heard. In both the cases, matter remained part heard. Let the matter be fixed on Thursday at 10:30.
Yes. All this matter, then your lordship can pass necessary orders.
This other matter also.
Others matter also, you can necessary orders can be passed.
Which
that
other
day
matters?
or these all.
Other matters may not be. Problem.
Yes.
Because those are not tagged with this.
Not tagged, but some date has to be given. That's why.
Okay.
So it can be then on that day.
The other matters also. No? This item numbers.
22 and 23.
23 and 23 also to be listed on Thursday. Okay. Thursday morning.
Because now it's 4:25.
Yes.
If I start, it will be because I have to go back also, man.
Yes.
Because I am here itself.
But only thing is that like Thursday.
No, I'll make it a point because your lordship is leaving at 12 o'clock. Before that, I want to finish it off, my lord. Before that means it will take 40-45 minutes, not more than.
Because
11:15 is a maximum. 11:15 is a maximum.
12:30 is fine
because my lord, this type of case, my personal appearance is more important than doing virtual, because there are a lot of things, judgments. If I put across, then it becomes more easier for the court.
Yes. What about the other two cases that these two cases? Can you give me the printouts?
Printout.
Which case? These two cases, the learned senior counsel has referred that 2021 19 SCC.
2021 19 SCC 706. And
These two cases,
2021 2 SCC 525.
These two cases are there here. These two cases are not. Is it there in the compilation? No.
25.
And if he can give me the printouts, because maybe like I'll have to take those cases.
One more case is there.
Printed from my
25
library.
SCC online 764.
Then I may make those available to me. These two cases, pages you have noted. Okay, he's giving me some.
One more case is there. 2025 SCC online SC 764. 3 cases he has cited.
Is there?
No, that is there.
Yes.
There is serious offences case.
Yes.
That is there. It is there. So all is written. 2 matters will be listed, and these 2 matters remain part heard. Will be listed at 10:30 Thursday.
Yes, ma'am. Deeply obvious, ma'am.
Awe puko mogol molo toshi visni amendo